Heard Miss
R.R. Bora.
R.R. Bora, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who submits that case diary has not arrived and prays for another date for producing the same. Prayer is allowed. Let this matter be listed again after 2 weeks at the date. 3rd of April.
Oh, please, madam.
My lord, item number 2 of court number 18, my lord. My lord, today it has come for motion, my lord. They are willing to take time, my lord. Let it be on 27th, my lord.
LCR may be called for. Because trial is going on. Copies of the orders it may be called for, and in the meantime, maybe.
But it is item number 2. 2. So why you are mentioning it will be otherwise called immediately.
Your lordship is 18 matter.
Court number 18, I'll be taking up court number.
Sorry, sir. Sorry, I thought.
All matters of court number 18, this court will be taking up.
Okay, thank you. I'm sorry.
Court number 24, item number 2.
Lordship, here, scanned copy of LCR, a report was called for, it has been received. Only 2 witnesses have been examined, my lord. There's an order probably, my lord, I've just seen. The bail application would be considered after examination of at least 5 numbers of witnesses, my lord.
Yes.
My lord, already 2 numbers of witness examined, lordship, and nothing has been mentioned and nothing has been materials against the.
Since when
specific
you are
person, lordship.
behind?
Already 275 days in custody, lordship. And other co-accused, lordship, already granted bail by the honorable court. Kindly come to page number, lordship. We find page number, lordship, 29, lordship. And otherwise, lordship, and the main accused number 1 already granted.
No, what was the allegation?
Allegation 302 is their, lordship. But apparently, lordship, and FIR is 6. And subsequently, lordship, nothing.
FIR is at page?
Page 60, lordship. Page 60. Translated copy, lordship. And Omen, lordship.
The petitioner is a woman.
No, lordship. And the victim, lordship.
The
And
deceased is a woman.
Omen, lordship. Page number 16, lordship.
What are the materials against you?
Nothing, lordship. As per lordship and statement of the informant, lordship, and one
Lordship,
executive.
there's an order. We
No.
can-
Lordship, whatever maybe, lordship, and
But the-
one more, already 4 dates already gone, lordship. No.
But
this
after
is
that
started.
order, so many dates have passed.
But here only 2 numbers of witnesses have been
Because
examined.
total there are 70
7
witnesses.
witnesses.
So
Only official witnesses have been
No,
examined.
informant is also.
1, 2
Nothing.
per.
Informant is not whispering any single word, lordship, against the present petitioner.
no,
lordship.
in the case diary, what are the materials against you?
Normally, lordship, and within the before 90 days, lordship.
Otherwise, because there is an order of this court that at least 5 material witnesses have to be examined.
That is
You have to
lordship.
wait for that.
Yes.
Otherwise, lordship, there is nothing. 275 days, lordship, gone, and another.
Then how would we overcome the earlier order?
Yes, so I am submitting, my lord. Since there is a judicial order,
Lordship, already 3 dates gone, lordship. I have collected, lordship. Now, lordship, I admit, lordship, but the 21/12/2023 date gone, lordship. No witness turned up. And 19/1/2020.
After that order, how many dates have been?
Lordship, 21/12/2023.
this
That's
victim was
19,
a,
19/1/2024.
she was a political worker. She was a secretary BJP of Goalpara district.
No, what is the allegation against the present petitioner?
Present petitioner, so witnesses will reveal that, my lord.
Nothing.
No, presently,
No,
because,
only 2
because
numbers
there
of
are,
witnesses have been
one
examined
of the co-accused has been released on
on
bail.
bail.
So what are the difference between the
Apparently, lordship,
difference in allegation against the accused
num-
who has been released on bail
Bail.
and who is still detained.
তুমি কোৱা বাকী কেইটা আৰু তোমাৰ মাজত কি চিমিলাৰ চিটুৱেটেড নেকি
What is the distinction between?
Distinction made lordship and the earlier granted bail Hassanul Islam lordship, and he is the elected working member, and the woman the deceased, and he is also the elected working member lordship, ward member lordship. And if there is anything lordship, at the present petitioner is a tractor driver lordship.
No, how will you overcome the observation of this court earlier that at least
That
five, you overcome you
is true.
find out a way.
That is true lordship, and otherwise 4
Then
days.
we have to wait. Then we have to wait till,
ইজনৰ নামটো কি
I am waiting lordship.
কোএকিউজৰ নামটো কি
when is the next date fixed?
Order yes.
When is the next date
Next
fixed in the trial
Dated
court?
4/4 lordship. 4/4
Let us
2020.
fix this case after 4/4. Let us see how many witnesses are examined. Heard Mr.
F.
F. Hawk, learned counsel for the petitioner. Also heard Ms. B. Bhuya, learned additional public prosecutor. In pursuant to the directions of this court by order dated 2024, learned Sessions Judge Gwalpara has furnished a report dated 15/3/2024, wherein it has been informed that only two witnesses, namely the informant within bracket PW1 and the one executive magistrate within bracket PW2 has been examined till 11/3/2024. Stop. Where is the order where it was observed that at least three, the earlier order? It appears from order
Lordship, order dated
eight,
page 33,
8/12/2023,
1812.
18/12/2023, that this court had observed that the bail application of the petitioner shall be considered by this court after examination of at least three material witnesses. It appears that till now only two witnesses have been examined and next date is fixed on,
কেতিয়া 4/4?
Mr. Hawk,
Next date 4/4.
is fixed on 4/4/2024. Therefore, let this case be listed again on after 4 at the date. Fixed on 9th of. Fixed on 19/4/2024.
Can it be earlier lordship before Eid lordship, and Eid is 11 lordship you feel, and if one was
Okay, on 9th,
attend maybe
on 9th,
9th হ'ব জানো? Means judicial order আছে ন? 5 জনৰ হ'ব লাগিব।
9th, on 9th of April
My lord.
2024, learned district, learned session judge Gwalpara
Gwalpara.
shall inform this court as to how many witnesses are examined on the next date, that is 11/4/2024,
No, 4/4.
4/4/2024. Fix. No, last line to cut. Let a report be called for from learned session judge Gwalpara, informing this court the number of witnesses examined on 4/4/2024. Let this case be listed accordingly on 9/4/2008.
Lordship, can the raise to be directed to obtain the further instruction?
The registry shall furnish a copy of this order to learned session judge Gwalpara for compliance.
Lordship obliged.
Item 3,
May I please. In this case, Lordship, one observation is made by this honorable court, Lordship, will find page number 20, Lordship, and after examination of victim, Lordship, and victim already be examined, Lordship, and we have collected the certificate copy, Lordship. Page number, Lordship, 20. And relevant portion start 22, Lordship, and last
Page number?
20, Lordship, 20. Page relevant portion,
Since
Lordship,
when you are behind bars?
Lordship, 350 days, Lordship, and 3/4/2023.
3, 4,
2023. 3/4/23. And 350 days.
where is the,
Lordship, there's an observation from this honorable court at page 22.
After examination-
Considering the nature of offense involved as well as past conduct of the petitioner in this case, this court is not inclined to grant bail to the present petitioner at this stage. Hence, the prayer for bail of the present petitioner is rejected at this stage. However, it is hereby made clear that after examination of the victim girl, the petitioner may approach the learned trial court and may pray for regular bail before
Yeah,
the learned trial
Approach,
court.
Lordship, and then page number, Lordship, 23, Lordship.
why it was rejected?
Page number 23, annexure 5. Rejected, Lordship. So kindly, out of 5, 6 accused, Lordship, all are in outside, Lordship. Only I am in custody. So stringent condition may be imposed, Lordship, already about 1 year almost.
What was your previous conduct which this order is mentioning?
Lordship, they are involved with dacoity case also. Is reflected in the order sheet at page 23, last portion.
Where is the testimony of victim?
Victim of testimony.
Lordship, at the subsequently I have collect, Lordship, and I have collect the certificate copy, Lordship, and
Lordship may find the allegations at page 24. Involved in dacoity cases, then they indiscriminately fired shots at police with AK-47.
In earlier case?
Yes.
as per the Lordship, sheep and cross, Lordship, all the accused person are implicated by the victim, Lordship. All the equally, Lordship. Their involvement is, as per the statement of the victim, is similar. But only all they are in custody, outside, but I am only in custody.
You file this evidence by filing an affidavit, or we will call from, two options are there. Either we will call for the testimony of the,
And affidavit, Lordship.
with a
Lordship may
copy,
call for a scan copy of the.
Collect certificate.
Hello.
you give a copy to the
All- and-
additional PP also,
Certificate copy.
so that she can go through it and make any objection.
Otherwise, Lordship implicating, Lordship.
No, she should go through it. Her,
খালি করবে একটু করে দিও না
heard Mr. F. Hawks, learned counsel for the petitioner. Also heard Ms. B. Bhuya, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Abdul Rahman alias Rinku,
দেখতে
alias Rinku, who has been detained behind the bars since 3/4/2023 in connection with Sessions Case number 188/2023. praying for his bail. Stop. It it is pertinent to mention herein that on an earlier occasion, the prayer for bail by the present petitioner was rejected by order dated 24/11/2023 by this court. However, while rejecting the prayer for bail, an observation was made that the petition, that after examination of the victim girl, the petitioner may approach the trial court and may pray for regular bail before the trial court. Now Now the petitioner has submitted that the victim has been examined as PW4. And after such examination, the petitioner had approached the trial court praying for bail. However, by order dated 23/2/2024, the prayer for bail was rejected, and therefore he has approached this court by filing the instant petition. It is also submitted by learned counsel for the petitioner that you will file an additional
Day after tomorrow may be listed.
that the petitioner may be allowed to file an additional affidavit by which he want to bring on record the deposition of the victim girl, which was recorded as PW4 by the trial court. The prayer is allowed. The petitioner may file an additional affidavit bringing on record the deposition of the victim girl. A copy of the same may be given to learned additional public prosecutor. Let this case be listed again on
Day after tomorrow.
20th. পিছত কৰিবা 20
on 20,
20
23/2024.
Publish.
This. You can take it back.
I think court
May it please your lordship. Court 39 application, my lord. Petitioners, they were arrested on 6/6/2023 and produced, my lord, on 7/6/2023. Till date, my lord, they are behind the bars for 9 months, 11 days today, my lord, from 7/6, my lord. Page 16 is the FIR,
What is the offense?
my lord, suspected opium, my lord,
Commercial quantity.
my lordship.
Then what is the ground on which you are?
Earlier, my lord, the bail petition was rejected, taking into consideration because the case was placed that the period of detention was the main contention, my lord. But, my lord, the new ground in this particular case is that, my lord, in the FIR as well as the forwarding itself, my lord, the investigating officer has clarified that the mandatory provisions of 42 and 50 has not been complied with. My lordship, for a moment, is kindly come at page number 16 is the FIR, my lord.
These grounds you have not taken earlier when you.
These grounds were not taken up, my lord.
So is it
only
open to
ground-
for you for taking new grounds which you forget to take on earlier occasion?
My lord, at that particular point of time, my lord, the bail was filed taking into consideration only, my lord, the period of detention. And my lord, one judgment was also placed, my lord. Page 16 for a moment, kindly peruse. The FIR, my lord. May I read, my lord?
No. Before that,
My lord.
where is the rejection order?
Rejection order.
Rejection order, my lordship will find it page 33.
Yes. And our objection is at para 8, page 35. Quantity of opium seized in this case is commercial quantity. Therefore, the embargo of section 37 of NDPSA comes into play.
Page para 6, my lord. The observation of the honorable court, my lord.
No, this is not a new ground. This ground was existing when you moved the bail on earlier occasion also. You
My
fail to assail that ground. This ground does not becomes a new ground if you fail to assail that ground on earlier occasion.
My
It
lord,
was
this-
there on earlier occasion also.
My lord, this order was passed on 2012-2023.
Yes.
And my lord, subsequently charges have been framed on, my lord, 11/1/2024. Then, my lord, this matter was fixed for, my lord, evidence, my lord. And the next date is fixed on 4/4/2024, my lord.
Lordship, there is an observation from this honorable court while rejecting the earlier order. Learned trial court is hereby directed to dispose of the NDPS case as expeditiously as possible.
Yes, what is your submission?
Lordship,
State of
since your lordship, the trial has begun, I think. Lordship,
Evidence has not been recorded, my lord. Next date is
the
4
status report we call for.
No, he is not pressing on the ground of progress of trial or delay in trial.
My lord,
He is on non-compliance of 42 and
50, my lord.
50.
That would come, your lordship, after completion of trial, my lord.
And my lord.
If any plea he wants to take.
Aspect will clarify, my lord, only when, my lord, the status report with regard to, my lord, the prosecution witness number 1 will come up, my lord. Because he is the authority who had done the search and seizure, my lord, and my lord,
Whether any witness has been examined.
my lord, so far as my information, my no?
I'll still reiterate my submission, my lord, whatever has been stated by my learned predecessor, lordship, my earlier PP. The quantity of opium is a lordship, the commercial quantity, and therefore embargo of section 97 comes into play. At this stage,
lord,
may I
the-
pray your lordship may not grant.
Re-
you
No, my
relief to
lord,
them.
definitely, my lord. If report is called for, my lord, status report, my lord, that aspect will clarify, my lord, whether, my lord,
Status report regarding.
regarding, my lord, whether any witness has been examined or not, my lord. At this stage, that is my limited prayer, my lord.
That would amount to
Because-
interference in the trial. Let
No,
the
no.
trial complete, my lord.
That is not what I'm saying, definitely. My prayer is limited, my lord, because these aspects has to be, my lord, taken into consideration.
No, what is your new ground?
New ground is, my lord, that section 37, my lord, there are 2 exceptions, my lord. Number 1, my lord, that, my lord, whether I have, my lord, committed the offense. And number 2, my lord, whether there is any possibility of, my lord, repeating the same. My past antecedent will clarify, my lord, that I have never indulged in such kind of activities earlier. Petitioner number 2 is a 75-year-old man, my lord. And my lord, if he gets convicted, my lord, probably he'll die behind the bars, my lord.
No, these are
So-
not the.
So, my lord, the status report, my lord, with regard to whether, my lord, PW1 has been recorded. So that, my lord, these aspects will get clarified that whether, my lord, section 42 and 50 has not been complied with. Otherwise, I'm submitting on the basis of, my lord, the materials available before this honorable court, that, my lord, the same has not been complied with. But the PW1 will be the best person to say, my lord, whether it has been complied with or not, my lord. And that is possible, my lord, only when the report is called for, my lord, status report. That is my limited prayer, my lord. At this stage, my lord.
Heard. Mr. M.K. Das,
Hello.
Learned Counsel for the petitioner. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner for the second time in connection with NDPS case number 54/2023, where in connection with section NDPS case number 54/2023, in which the petitioner has been detained behind the bars since 7/6/2023. The petitioner, learned counsel for the petitioner, has submitted that though his earlier petition was rejected by order dated 2012-2023, however, he has assailed some new grounds for grant of bail in this petition
Next one.
and to consider those grounds, the testimony of PW1 would be of relevant consideration. And therefore, he has prayed for calling for a status report from the trial court as to whether the who is PW1?
Is
Josh.
28, my lord. Jugal Deka is the informant and he is the one who
As to
examined
whether
the
the
certain seizure.
informant is examined or not. Hence, let a status report be called for from the court of learned. Which court?
My lord. NDPS, Tinsukia, my lord. Special court. my lord.
Special court in Tinsukia regarding the fact as to whether PW1 has been examined or not. And if the testimony of PW1 has been recorded, a scanned copy of the testimony may also be sent along with the status report. Let
Raised to
ca-
be directed.
let this case be listed on fourth
Fourth, my lord, next date is 4/4/2024.
after Bihu. On 19th April.
Lordship raised to be
The
directed.
registry shall take steps for procuring the said report from learned session, special judge Tinsukia.
Deeply obliged.
Item 5.
May it please the lordships. My 439 application, and I was arrested and forwarded on 14/8/2023, my lord. And thereafter, my lord, 2 witnesses were examined in this case, my lord. Out of 10 witnesses, my lord, 2 the witnesses were examined, they were declared hostile. And third independent was the prosecution declined to examine, my lord, on 14/7/2023. And thereafter, my lord, not a single witness has turned up, my lord. And I'm behind the bar for last 1 year, 7 months, 4 days, that is 582 days, my lord. So my prayer, my lord, is considering the length of detention, my lord. The prayer of this petitioner may kindly be considered, my lord.
When was your earlier petition rejected?
It was last rejected on, my lord, page 35, my lord. There, my lord, we raised the there, my lord, we argued on the ground of default bail, my lord. Page 35. It was rejected on 30/11/2023, my lord.
Okay, we'll call for a status.
Madam.
report. Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed for the second or more than
It's third time, my lord.
for the third time by the petitioner, namely Abdul Jalil, who has been detained behind the bars since 14/8/2022 in connection with special NPS case number 119/2022. The ground on which the petitioner has been praying for bail in this case on the ground of prolonged incarceration, as only 2 witnesses
2 witnesses examined, my lord.
have been examined till date, according to learned counsel for the petitioner. Stop. Let a status report of the witnesses examined in the NDPS case number 119/2022 be called for from the learned session judge, learned special judge Karimganj. Stop. Registry to procure the aforesaid report from the learned session judge Karimganj, learned special judge Karimganj. Let this case be listed again on after Bihu.
My lord, can it be on 4th of?
On 4th of April 2020.
Deeply of like no.
Item 6.
May it please your lordship. Regular bail application matter arrested on 9/2/2024. The FIR is at page 11. A very longish
This is your first petition.
minor.
Okay. We'll have to go through the case diary.
My lord, my implication is only from this forwarding report, my lord, that I have annexed at page 23.
Page 20.
FIR, my lord, there is no reference to me, no implication, my lord, not even a whisper. That is entirely against somebody else. Your
Raju,
lordship will kindly come to page 23, my lord.
yes.
The forwarding, my lord. That is also directed, my lord, at the top.
What is the allegation?
Allegation is, my lord, my allegation is, my lord, your lordship will come page 23 at 2, clause 2 bottom. During investigation, it is found that below noted arrested accused person involved
Making
in.
forged documents.
Yes, my lord, NOC sale deed power attorney for his personal gain.
Since when you are behind the bars?
My lord, since 9/2, my lord,
9/2/24.
9/2.
We have to peruse the case diary.
And it also says, my lord, that I am a habitual offender, my lord. In this respect, I would just like to place one document before your lordship will definitely call for the, my lord. This is the, my lord, order passed by this court in respect of the petitioner on an earlier occasion. My submission is that, my lord, the allegation, my lord, these are very general and stereotype, my lord. There's nothing to substantiate, man. In that, my
This
lord,
is
it is
with
against
regards to a
Article
different police station case.
Jagiro.
This or
That is, my lord, against any case, my lord. Police were looking for him, so they came before this court, my lord. I was not there in that petition, my lord. And
No,
in
this
that
order-
report was called for, my lord, and the concerned police station said that there is no case lodged against him, my lord.
in this order,
Yes, ma'am.
but this is a different case.
This is a different case, same police station, my lord. No, no, my lord, why I am referring to this is because the forwarding says that person is habitual offender at clause 4. These, my submission
Okay.
is that these are very
Oh.
general. My lord,
Only this case is pending, no other case is pending
My
against.
that is nice.
Okay, still we have to go through the case.
My lord.
Heard, Mr. Yes, but. B.D. Goswami, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure has been filed by the petitioner Raju Ahmed, who has been detained behind the bars since 9/2/2024 in connection with Jaggi Road PS case number 300/2023. Stop. Considering the nature of allegations made in the forwarding report dated
Dated 9/2/24.
9/2/24 against the present petitioner, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing
27, lordship.
27/3, 27/3
Not
for
27, no, first. But first of April. ma'am.
okay. First of
May I just pay that the medical report? Huh?
4th of April.
No,
5th,
First of April.
1st of April, okay.
That's what.
1st of April.
My lord, may I also call, my lord, make a request for calling the medical report? He's not well.
Learned counsel for the petitioner has submitted that petitioner is also not well,
From the jail, ma'am. Jail authority.
and therefore also call for a report regarding the health condition of the petitioner from the superintendent,
Jail report will be.
from the superintendent of district
Morigaon.
Morigaon, district jail Morigaon. Let this case be listed accordingly on 4th of,
On first of April.
on 1st of April.
Much obliged.
Board number 18, item number 1.
Lordship, only one more matter is left of this court, 42.
Okay, let us finish that.
Item number 42.
Yeah, Your Lordship. Lordship, this is 439 bill application.
तुम्ही कोण आहात? तुम्ही सुद्धा कोणता निवेदन देतो?
CD was called for in the last cycle, Your Lordship. Lordship,
Sorry,
it's
full?
439 bill application under section 120B
No,
379.
this is a interlocutory application.
Lordship,
I-
তোমার নামটা কি?
Item
No.
number,
42.
not 42.
42 হয় তোমার?
42.
নহলে 24 ও 42 আছে।
Okay.
Sorry, Your Lordship, code number 18. My item is code number.
Because this is an
18.
application which I have found, my lord, for cancellation of bail application.
Yes, this
There's
is
all-
not your
Yeah,
case.
to-
Yes,
পুরা
yes.
নহয়।
Sorry, Your Lordship.
42, I don't know who is appearing, 42. For the informant, Mr. S.C. Biswas.
We'll take
can
it up
show-
later on.
Lordship,
We'll take it up later on. It's of nothing.
Item 1, code number 18.
May I please, Your Lordship? Herein, Your Lordship, page 9 is the FIR, Your Lordship. Page 9 is the FIR, Your Lordship. Basically, in the FIR, Your
Since
Lordship,
when you are in jail?
Lordship,
Since when you are in jail?
I am in 4/3/2024, Your Lordship.
4/3/2000.
24.
Okay. Where is the rejection order by the,
Rejection order, Your Lordship, I have not annexed, Your Lordship,
why?
because
That is required. Have you moved the bail application before any other court?
I don't know it, Your Lordship, whether they have moved or not, Your Lordship.
No, either you have to answer this question, whether you have moved, or if it is no, then the situation would be different. If it is yes, then you have to annex the rejection order as per the prevailing notification.
But I think there is no any bar, Your Lordship,
No,
because the
there is
sentencing
no bar,
form-
but you have to inform the court whether you have moved. Have you is there any affidavit that your earlier, there is no rejection by any other court?
Yes, sir.
Where is the affidavit? You find out whether,
No. I think no bail petition has been moved, Your Lordship, before the court below.
why have
But-
you, which
But
did,
regarding latest notification, Your Lordship, no bail petition has been moved before the court below. But if there is any bail petition moved, that has to be mentioned, Your Lordship.
so you have not moved?
No,
Where is the affidavit to that effect? Why have you not approached the court under section 437 when before the magistrate court in Gwalpara?
But
Though this court can take up
yes,
if
yes.
you are in custody, but what is the reason for directly rushing to this court under 439 when you had other options?
Under section 437, Your Lordship, they have moved or not, I don't know, but before.
No,
Court of
that you have
Session,
to
Your
know
Lordship,
before coming to this court. You cannot say, I don't know. You have to answer that either I have not moved or it is rejected and this is my rejection order. On these grounds, court has rejected.
Lordship, then after some time, Your Lordship, you
Yes,
take, Your Lordship.
You
that
take
I-
the instruction. Piece of
But-
law.
But my query,
Yes.
after some time, Your Lordship.
Item 2, My lord, let the LCR be called for. My only prayer at this stage would be, my lord, let it come up on 27th or 28th because 3 years will expire by then.
This is NDPS.
NDPS, my lord, Kamrup Metro within Guwahati city.
What is the status? How many?
Let us have 3 years, my lord, hardly 2 or 3 witnesses.
You are in jail since last 3
3
years.
years. On 27th, 3 years will expire.
Okay. Heard, Miss, yes, heard, Mr. M. Vishwas, learned counsel for the petitioner, also heard Miss N. M. Deka, learned counsel appearing for NCB. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mahendra Singh, who has been detained behind the bars since 1/4/2021 in connection with NDPS case number 46/2021 corresponding to NCB crime number 8/2021 under section 21 within bracket C/29 of the NDPS Act, pending in the court of learned Session
Judge Amin Gau.
Session Judge Amin Gau. Stop. Let the scanned copy of the case record of NDPS case number 46/2021 be called for. Let this the registry to take steps for procuring the scanned copy from the trial court. Let this case be listed again on
28th.
28th.
My lord, liberty may be given to them to file objection. Otherwise, again on the next day, time will take.
Okay, Lordship, we will file
Liberty
our
may be given, my
objection.
lord. I'm experienced.
The learned counsel for the respondent prays for allowing the them to file an objection against the prayer of bail made by the petitioner. The prayer is allowed. The objection may be filed before the next date fixed. Let this case be listed accordingly.
Meet your lordship. Offences are under 21C and 25 of the NDPS Act. And the FIR is at page 13.
Charge sheeted matter, my lord.
Charge sheeted matters. And your lordship, as per the FIR, one information was received on 11/10/23 that one Asaruddin had concealed some drugs in his dwelling house. Now, when the police went there to search him, he did not find Asaruddin and has arrested me. I am the wife of Asaruddin. I was
No,
picked up
no
on the,
charge sheet has been laid.
yes,
Charges are framed.
charges have not been framed. I think it is fixed for appearance of the absconders, the other two accused, co-accused.
So on what ground you are praying for bail?
First of all, your lordship, I was not in conscious possession because on 11/10/23, when I was arrested, one day prior to that, one lordship, Kamrul Islam, he came to my
This
house.
is for the first time you are approaching for
Yes,
bail.
your lord. Yes, your lord.
Before this, you have not
No,
moved
no.
any bail application,
No,
even during investigation stage.
no. This is the first bail application. Now, one day prior, one bag
Oh.
was handed over to my husband.
Okay, heard Mr.
That's the
S. Dr. Learned counsel for the petitioner. Also heard Mr. B. Goswami, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Ayesha Begum, praying for bail of the accused Asaruddin, who is her husband, who has been detained behind the bar since 12/10/2023 in connection with Ratabadi PS case number 240/2023 corresponding to NDPS case number 135 of 2023 pending before the court of learned Session Judge Karimganj. Stop. Considering the fact that the This case involves commercial quantity of contraband, comma, perusal of the case diary as well as scan copy of the case record of NDPS case number 135/2023 would be necessary. Hence, call for the scan copy of the case diary of Ratabari PS case number 240/2023, as well as scan copy of the case record of NDPS case, special NDPS case number 135/2023 from the Court of Learned Session Judge Karimganj. Let this case be listed again on the registry to take steps for procuring the scan copies. Let this case be listed on 19th of April.
Your Lordship, another thing I want to show is that I am in judicial custody for 158 days and I'm along with the infant.
You are a lady.
Yes, I'm a lady.
Etu kati diyo.
I'm the wife of Asaruddin.
The petitioner is Aisha herself.
Aisha Begum.
Got covered basically paying for bail of husband. Paying for husband to kati. No. The petitioner herself. The bail of the petitioner herself.
So considering this interim.
Okay, let us see. No entry.
Obliged.
I did hold.
Once a 439 application, my lord. Whether they were arrested on 5/3/2024, my lord. The case regarding, my lord, the cattle's, my lord. And I think, my lord, the diary will be required, my lord.
Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. B.B. Goswami, learned B.B. Gogoi, learned additional public prosecutor. Call for the case diary. Fixing
28.
3 for case diary.
In fact, well, I had the originals, my lord, the diary come. What origin? The challenge. Challenge already on the.
Let the diary come.
On that page.
I did 5.
May I please for your lordship, this is a 439 application. Your lordship, the allegations are under section 419, 420 of IPC, read it section 66B of the IT Act, your lordship. Your lordship, I am behind the bars for last 34 days, your lordship. The crux of the FIR is that.
Let the case diary come. Case diary perusal would be
Yes,
needed.
27, my lord.
Heard
So that
Mr.
27. huh?
Heard Mr. What is your name? P.K. Das.
A Raja.
A. Rajak, learned counsel for the petitioner, also heard Mr. V.B. Gogoi, learned additional public prosecutor. Call for the case diary. Fixing 27/3 for case diary.
One buzzer.
Obliged.
I did 6.
May I plead your lordship? This is a section under 439 application lordship. Case registered under section 20B, subsection 2, capital B. of
20B?
NDPS Act.
Yes.
Case
Why?
diary may be called for lordship.
Okay, case diary would be required. Why your prayer was rejected by the trial court?
Trial court reject position.
No, lordship. First application lordship.
You have not moved. Why have you not moved your application before trial court when it is 20B?
Lordship, my junior sent
No reason.
Heard Mr.
S. Hawk lordship.
Mr. S. Hawk, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Fixing
9-2 or 9-4.
9/4.
Obliged.
I did 7. May I plead the lordship? Lordship, this is 439 bail application under section 120B, 379, 411, IPC and Cattle Preservation Act. FIR is space 11, your lordship.
Where is the
Where is that?
rejection order?
Lordship,
Your bail was rejected by any other court?
no, no,
You have first
first,
directly approached this court without approaching the, and this is my query only. I'm not saying anything.
Lordship,
Whether
for Annexure 3, I will close order.
page,
Kindly come to the page number 19, Your Lordship.
page number 19,
19.
page number,
Sorry.
Voucher,
Page number 16 to 18, Your Lordship. Sorry.
reserve voucher, purchase.
page number
Page number 16, Your Lordship.
16.
16.
ভুল কৰিছা। Put 16 ঠিক আছে 1602 reject order.
Okay. Let us call for the case. Heard, Mr. What is your name?
M. Hussain.
Heard, Mr. M. Hussain, learned counsel for the petitioner. Also heard, Mr. B.B. Gogoi, learned additional public prosecutor. Perusal of case diary would be necessary for consideration of the instant bail application. Hence call for the case diary. Fixing? Yes, Mr.
24.
24 for case diary. Call after something.
May I please?
Charge sheet হয়েছেন না? নাই, CD.
Charge sheet has been laid. It is still pending investigation.
Yes, Lordship. Kindly call
How
for the
many days you are behind the bar?
arrested date on 6/11/2023.
Heard, Mr.
P.
P. Teli, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Since this is a case involving offense involving commercial quantity of contraband, hence perusal of case diary would be necessary. Stop. Hence call for the case diary of Ajo PS case number 639/2023. Stop. Fixing
44.
444 cases.
Hello.
May I please, Your Lordship? Lordship, kindly may allow for time being, Lordship. My senior is Legoni, court number 27. Lordship.
Item number 11.
Lordship, in this matter, Mr. Dinath is appearing. He is on legs in another court, Lordship. Can he be passed over for the time being?
Dinath for,
Lordship,
for
senior government advocate, Lordship.
Lordship, timing. Item 12.
11 and 12 are same.
Accepted. 11. Item 14.
My please, Your Lordship. Herein the petitioner, he is the registered owner of a vehicle, Your Lordship, which has been seized. Which has been seized in connection with Doshaigaon PS case number. And the vehicle was carried some cattle, Your Lordship, and regarding with that allegation, the vehicle was seized along with the cattle. And the petitioner filed a petition for releasing the vehicle on Zimma, and that has been rejected. And that is page 22, Your Lordship. So at this stage, Your Lordship, I am only seeking for calling status report, Your Lordship.
status report of,
A status report means, your lordship, the report from the concerned police station, your lordship.
yes, whether the vehicle is required for
Yes.
further investigation. or not.
Yes.
Where is the rejection order?
Page 22 years. Page 22.
Page 20.
22E.
On what ground the prayer was rejected?
Prayer was rejected.
Is required for investigation. Okay,
Yes.
okay. Heard Mr. M. Khan. Heard Mr. A. M.
A.M.
Khan. Learned counsel for the petitioner. Also heard Mr. B. B. Gogoi, learned additional public prosecutor. This application under section 401/397 of the Code of Criminal Procedure has been filed by the petitioner Nobikul Islam, impugning the order dated 11/3/2024, passed by learned SDJM within bracket M, Gosaigaon in Gosaigaon PS case number 14/2024, rejecting the prayer for Jimma of the vehicle, which was seized in connection with this said case. Stop. It appears from record, it appears on perusal of the impugned order that the prayer for Jimma was rejected by the learned SDJM within bracket M, Gosaigaon, on the ground that the vehicle was still required for the purpose of investigation. Stop. Since no, if on 11th it is required for investigation, do you think that within these 7 days it will not be required?
Then on 111, that means I am actually challenging that order, your lordship, because the vehicle here is.
No, the IO will again say that it will be required for investigation within 7 days. Or you are hopeful that the requirement may not be necessary, it may not be required.
Actually, your lordship, by filing this, your lordship, I have challenged that order, your lordship. On that ground, the rejection ground is not appropriate, your lordship.
Let us take instruction, my lord, from the IO, whether further that custody.
What was the last one? Last one, yes. So let a report be called for from the investigating officer of Gosaigaon PS case number 14/2024 as to whether the vehicle bearing registration number NL01AB1285, which was seized in connection with the case, is still required for the purpose of investigation or not. Learned additional public prosecutor shall procure the report and shall place it before the court on the next day.
5-4.
That is on 5th of April 2024, list accordingly.
All right.
Item 14.
May I proceed? This replication has been filed, my lord, against the impugned order dated 19/12/23. Lordship will find at page 22 is the impugned order, which was rejected on the ground that the Jimma
prayer.
was, yes, ma'am. And
Jimma of money.
Actually, my lord, amount was seized from the house of the petitioner, alleging that he has stolen that amount from his company. But thereafter, after trial, the petitioner has been acquitted honorably, and the complainant has failed to prove that that is their money. And totally they have proved that he has misappropriated any amount from them. But actually, my lord, the petition was filed for under section 452, not 51. Earlier, Jimma was given to the complainant. Lordship will find page 21, the earlier order.
Just saying. Yes,
By this order, the Learned CJM has directed the police to give Jimma of the seized amount to the complainant, that is to the informant. And thereafter, it was directed to release the seized money on accepting a bond of the same amount with condition that the petitioner will produce the seized money as and when directed by the court. So after completion of trial and
no, whether it was given in accordance with that order, because that order was of 2016.
yes, my lord. But by this, it is by page 22, it is reflected that after perusal of blackouts, it was found that it is still in the under the Jimma of complainant, informant. So petition was filed under section not for Jimma, for delivery, and that was misconception by the trial court, my lord. So I think at this stage, notice may be issued, record may be confirmed.
Who is respondent number 2?
Two is the my lord informant.
Now money is with him. Money
Yes,
is with
yes,
him.
money is with him.
Money is with whom?
Yes, yes, your lordship, please page 22, page 22. Order of the court below, page 22.
Yes, Rakesh Mantri.
No, money is not. with him.
Yes, money has already given Jimma of this person, person number
No,
2.
the order has been passed in 2016. But the money was not handed over to him in accordance with the order. Is it your case?
No, madam. Money was given Jimma to the informant.
Okay.
Informant.
That is number 2.
Number 2.
Respondent number 2.
Respondent number 2. Who was the
Or to the informant?
informant,
Oh,
not to the accused.
he has not.
He has not handed over to the court, and court has by misconception has passed this order rejecting my application that second Jimma cannot be given. Because my petition was not for Jimma, for delivery of the property, my lord. After completion of trial under section 452. Section 452, lordship will find
Yes.
lordship may I read, madam. Order for disposal of property at conclusion of trial. When an inquiry was
No such order was passed.
no
by
such
the-
no such order.
While delivering the judgment of acquittal.
No, while
In the
deliberating,
in the
No,
judgment,
no.
mention is
No,
there.
no
How
mention.
the
It was mentioned in the judgment that the money has been kept under the police, and thereafter it has been seized and given to the Jimma of informant. And no order was passed for disposal of the property.
That Jimma was for custody or
Custody,
custody only.
custody. During the trial. And that is after conclusion of trial.
heard Mr. S. Nath, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor. This application under section 401/397 of the Code of Criminal Procedure has been filed by the petitioner Benu Bhushan Nath, impugning the order dated 19/12/2023 passed by learned Chief Judicial Magistrate, Kamrup Metro, Guwahati in GR case number 670/2016, whereby the prayer for releasing the seized amount of cash seize amount of money, that is rupees 4,80,000, 83,000 and 30 only, was rejected by the trial court. So issue notice to the respondents and call for the case record of GR case number 670/2016 from the Court of Learned Chief Judicial Magistrate, Kamrup Metro. As learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be sent to respondent number 1. Stop. However, comma, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks.
Yes.
This accordingly.
After view. 22.
No fixed date. After
Oh,
4
yes, yes.
Published.
May I please? Lordship, in this case, NBWF issued a claim to petitioner. Lordship, kindly have a look at page 14.
Page number
Page 14, annexure 2,
14.
Lordship.
This order you are impugning.
And Lordship, not
This,
so.
this is the impugned order.
No.
Okay.
By this order, he was released on bail, and thereafter he has a Lordship Levar went to Bangalore, and notice someone was issued to indicate
Released
her.
on bail
In course of investigation, he was
during
arrested, Lordship,
investigation.
and thereafter he was released on default bail. Lordship. And Lordship, thereafter, Honorable Court issued summons. That is, Lordship, kindly have a look at page 19. Someone was served, but he was absent, for which W was issued.
So in-
Lordship,
in spite of service of summons, you failed to appear.
Lordship, that is true, Lordship, but I was not in my home. I was at Bangalore, Lordship, is a Levar, Lordship. That may be considered, I am ready to face the trial, Lordship. Lordship may,
Now, what is the last order? Only NBWA.
Lordship, NBW, and last order, Lordship, it was passed on 1/2/2024.
Where is that order?
Lordship, that is not here in this petition. In that order also, NBW issued, as petitioner failed to appear, Lordship.
Now, what is your submission?
Lordship, my submission, he will, Lordship, face the trial, Lordship. Warrant may be stayed.
Why you did not comply with the order earlier?
Earlier, Lordship, I was out of station, that's why.
Yes.
My lord. Although he said that he is out of station, my lord, but not any documents regarding why he has not
Lordship,
complied or
it is a,
where
Levar,
is
Lordship,
here, my lord.
what document?
Where? Out of station? Where?
Lordship, at Bangalore, Lordship. I have stated.
And
in my
warrant-
petition
When is
that-
the next date fixed?
Warrant of arrest was
Lordship, I have, no, within 15 days, he will
No,
appear.
when is the next date fixed?
I have no instruction, Lordship. Lordship, only 15 days time may be given, he will appear. 15 days or 1 month.
Mr. L.R. Majumdar, learned counsel for the petitioner. Also heard Mr. B.
Sharma,
Sharma,
my lord.
learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioner, namely Fazal Ahmad Laskar, alias Fazal Ahmad, praying for quashing the impugned order dated 7/11/2023, whereby 7/11/2023 passed by learned Chief Judicial Magistrate Kachar in PRC case number 1889/2020, whereby the court issued non-bailable warrant of arrest against the present petitioner. It is submitted by learned counsel for the petitioner that during the course of investigation of the case, the petitioner was granted default bail by order dated 17/9/2019, passed by learned Judicial Magistrate First Class Silchar Kachar. However, it is also submitted that after filing of the charge sheet, summons were issued to the petitioner and same were where is the summons order?
No, that is.
It is
No,
not-
no. Lordship kindly have a look at.
You have
290
received the summons,
Look, family member receipt.
the family members of the, what was the last time? Last time. Exactly. Petitioner, which were received by the family members of the petitioner, as he had gone to the gone to Bangalore for earning livelihood. Now it has come to the notice of the petitioner that already non-bailable warrant has been issued by the trial court against him. It is submitted by learned counsel for the petitioner that as the petitioner is a laborer and is ignorant about the procedures, he failed to appear before the trial court. However, he is willing to appear before the trial court and face trial in PRC case number 1889/2020 and has prayed for facilitating his appearance before the trial court. Stop. Learned additional public prosecutor does not oppose the prayer as the petitioner is willing to cooperate in his trial. Stop.
And he will file my appropriate application before the court, my court will consider as well.
Considering the submissions made by learned counsel for the both sides, this criminal petition is disposed of with a direction to the petitioner to appear before the court of learned Chief Judicial Magistrate. Where it is pending?
Lordship, it is
Chief
Chief Judicial Magistrate Kachar.
Learned Chief Judicial Magistrate Kachar Silchar within 15 days from the date of this order. And to facilitate his appearance before that court, the non-bailable warrant, the operation of non-bailable warrant of arrest issued against the petitioner shall be kept in abeyance. On appearing before the court of learned Chief Judicial Magistrate Kachar, the petitioner may make prayer for any other relief to which he is entitled to. With this observation, this criminal petition is hereby disposed of.
Right.
Item 16.
Please, your lord.
16. 15 go.
This case is arising out of an NI Act case, Lordship, pending before the CJM Tinsukia, Lordship. In this case, Lordship, due to non-appearance before the learned court below, Lordship, NBW has been issued against the petitioner, Lordship. The first NBW was issued on 8/4/2021, Lordship.
21.
Lordship, 21. Thereafter, the next date is fixed on 19/4, Lordship, and same NBW is in force, Lordship.
Now, what was the last order?
Last order was Lordship, page 27, it's 22/2/2024, Lordship.
What is your submission?
My submission is that I have categorized.
Why have you not appeared when summons were
Lordship,
issued?
Look, I have categorically stated in my petition at paragraph 3, Lordship, that my lord, due to some misunderstanding and cooperation between the learned advocate and the petitioner, Lordship, this has been happened, Lordship. I have mentioned categorically in the paragraph number 3, Lordship. May I read the whole paragraph?
No, now what is your submission?
I will appear, Lordship, because due to this type of misunderstanding, I could not appear, Lordship. But
What was misunderstanding?
because Lord, the at first I was given to understand that the matter is going to be settled by the other side also, Lordship, on mutual understanding on, and thereafter, Lordship, the advocate, the learned advocate engaged by the petitioner, Lordship, he has perhaps taken more steps, Lordship, as per the advice of the petitioner, Lordship. So I will appear.
Okay,
Lordship.
let him appear.
It is the NIF case, my lord, but
Okay.
several occasions he is defaulted.
Here state is not a party.
Not a party.
Third, Mr. D. Hajarika, R. Fukon, learned counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure, 1973,
State respondent number 1, my lord.
has been filed. Also heard Mr. B. Sharma, learned counsel for respondent number, has been filed by the petitioner Shri Vishwajit Bhagavati, impugning the order dated 22/2/2024 and earlier orders by which learned Judicial Magistrate First Class, Dibrugarh had issued non-bailable warrant of arrest against the petitioner in case number within bracket NI Act 91/2016. Stop. It is submitted by learned counsel for the petitioner that the respondent number 2 had filed a complaint case, filed a CR case number 91/2016 under section 138 of the NI Act against the present petitioner. And the petitioner has engaged an advocate to defend him in the said case. However, it was during the pendency of the said case, it was made to known to the petitioner that the case there is a possibility of compromise between the petitioner and the respondent number 2, and thereafter, due to communication gap, the counsel for the petitioner did not take steps in the said case, and hence non-bailable warrant of arrest were issued against the present petitioner. Now it is submitted by learned counsel for the petitioner that the petitioner is ready to appear before the trial court on next date fixed, that is on 19/4/2024. And he may be given interim protection so as to facilitate his appearance before the trial court. Learned additional public prosecutor submitted that as the petitioner is willing to cooperate in his trial.
But he is defaulted in several occasions, last several occasions, he is not appeared before that.
These dates were known to you.
All dates not known to me, Lordship.
Though the petitioner has defaulted, learned additional public prosecutor has submitted that on perusal of the record, it appears that he has defaulted on several occasions from appearing before the learned trial court. Stop. I have considered the submissions made by learned counsel for both sides and peruse the case records. Peruse the materials available on case record. Considering the grounds stated by the petitioner in this criminal petition, as well as considering the fact that the petitioner is willing to cooperate in his trial and ready to appear before the trial court on the next date fixed, that is on 19/4/2024. This criminal petition is disposed of with a direction to the petitioner that he shall appear before the learned trial court, that is the court of appear before the trial court, that is the court of learned judicial magistrate, first class Dibrugarh, on 19/4/2024. Stop. And to facilitate his appearance before such court, before the said court, the operation of non-bailable warrant of arrest issued against him shall be kept in abeyance till 19/4/2024. Stop. On his appearance before the trial court, the petitioner may seek any further relief to which he is entitled to under law. With above observation, this criminal petition is hereby disposed of.
Right, Mr. My lord, this is for 482, my lord, for washing of the FIR, my lord. My lord, the petitioner, so far relating to the petitioner, my lord, FIR is at page 11. The FIR is of dated 13/11/2018.
At what stage the
That is what, my lord, I have come now, my lord. When this
it is-
FIR,
investigation is going on?
my lord, nothing has been revealed, neither I has been called for. I came to know of this proceeding, my lord.
You are named in the affair.
Name, my name is at serial number 3, my lord.
Ritesh Lekh. What is your ground for paying for question?
Ground, my lord, the proceeding, my lord, has been lodged by the informant with oblique motive. And this proceeding, my lord, perhaps, my lord, police have investigated and found that truth, my lord. But if your lordship will see the FIR,
Found the
still-
truth means
found that truth, so far the involvement, my lord.
you are not involved.
Yes, ma'am.
Then why are you praying for quashing? They will file final report against you.
My lord, what is happening, my lord? The proceeding, my lord, if your lordship see page 13, till now, my lord, petitioner do not know whether any case number has been registered and learned judicial magistrate first class, my lord. Is proceeding, page 13, top page, if your lordship will see, till now, my lord, it's Hualkusi PS case number 92 and 18, my lord. No, my lord, DR case or police case has been furnished and the status report of the investigations. Perhaps, my lord, this is manifestly instituted by the informant and that is kept pending, my lord.
Okay, let us call for the
Yes,
case.
my lord. My lord.
Heard Mr. B. Borua, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Shri Jagadish Deka, praying for quashing of the FIR dated
13/11/2018.
on the basis of which Swalkuchi PS case number 92/2018 has been registered. Stop. Perusal of the case diary may be necessary for consideration of the instant criminal petition. Hence call for the same. Fixing? When?
From Swalkuchi, my lord. 3rd April, my lord.
3rd April for case diary.
From, my lord, judicial magistrate first class,
No,
pending, my lord.
Just a minute. The
pending হয়ে গেলে স্যার
informant is the,
Informant, my lord,
before that, before last line, fixing. Issue notice,
My
issue notice to the respondents. Since learned additional public prosecutor has received notice on behalf of respondent number one, no formal notice need to be issued to respondent number one. However, as regards respondent number two is concerned, the petitioner shall take steps for issuance of notice on respondent number two by registered post with AD within 3 days from date of this order. Fix.
My lord, I have a prayer, my lord. If the scan copy of the LCR is called for, my lord.
No, we don't know about LC.
My lord, my lord.
Let
There-
us call for the
From the police.
My lord, it was mentioned in page 2, my lord, pending before the land judicial magistrate first class Hazo. First, we will take instruction from my lord, whether
us
CD,
get the
my
report.
lord, my lord,
Fix on.
my lord.
Obliged.
Thank you, Your Lordship. Lordship, this is a quashing petition 482 against the 498A filed by the wife, Lordship. In fact, in this case, what happened, Lordship, the petitioner married the opposite party.
Quashing of
Lordship.
the complaint.
Yes, Lordship.
Okay.
18.
I have received the notice, Lordship. Summons, Lordship, page 28, annexure 3.
What is the ground for quashing?
Ground, Lordship, in this case, the petitioner married the opposite party, Lordship, without knowing the fact that she is a wife of another person, Lordship. And after marriage only, he can come to know that she is a wife of one Zakira Hussain, Lordship. That is annexure 1, Lordship, page 16. He already filed a divorce case against that person, Lordship, and that was subsisting at the time of marriage of the petitioner, Lordship. Page 16, Your Lordship, kindly see annexure 1. Petition under section 2(8) of the Dissolution of Muslim Marriages Act 1939 as amended up to date. So when he came to know that there is she is a married wife of another person, Lordship, accordingly he filed a title suit. That is annexure 2, page 21. Lordship. As Lordship, as per Mohammedan law, Lordship, a married woman cannot be a wife of another person, Lordship. That marriage is void, Lordship. কোন পরিবেশে মেরিজের জায়গাতে আছে মেরিজের জায়গাতে
Yes.
So after filing this title suit for divorce, Lordship, against the opposite party, she served the notice of 498A, Lordship. So I am praying quashing of that petition.
After filing divorce petition, she filed 498 case.
I have received it, Lordship, after filing my title. She has filed it in the date is 22/11/2023, and I have
Before you file the
before
divorce-
my case, Lordship, but it has received, I have received the notice very recently, Lordship. The date was fixed for appearance 14/3/2024. But her divorce case was prior to my marriage, Lordship.
We'll issue notice.
My lord.
Lordship. Only my prayer, Lordship, it has to be state, Lordship, is a genuine ground, Lordship, as per Mohammedan law, Lordship. Marriage with a woman undergoing a Lordship, that is section 256, Lordship. It is not lawful for a Mohammedan woman to have more than one husband at the same time. A marriage with a woman who has her husband alive and
Who
is
are respondent number 2, 3, and 4, 4 and 5?
respondent
No,
number,
no, petitioner number 2, 3, 4, and
father, mother, and one aunt, Lordship. Of the petitioner, number 1 is the husband, 2 is the father-in-law, 3 is mother-in-law, say the Shamim Yasmin sister-in-law, and 5 is aunt of the petitioner number 1.
And what is the allegation against you in the complaint petition?
Lordship,
Where is the complaint petition?
page 28, Lordship.
What is the allegation? This,
Page 29 married, that after marriage, both the complainant and the accused number one started their conjugal life at the residence of the accused number one by taking all the Sridhana properties given to the complainant by her parents. That thereafter on 16/6/2023, the complainant and the accused number one have executed a marriage agreement before the notary public Bongaigaon and continued their conjugal life at the residence of the accused number one. That after few days of the marriage, the accused number one, upon instigations and advices from the accused number 2 to 5, has started physical and mental torture
this
on
is
the,
the allegation.
yes, Lordship.
Now, what is your ground?
My ground is that, Lordship, there was no such allegation. It is only because when I came to know that she is a wife of another person, then immediately we have taken step, Lordship.
But before your filing divorce, she had filed 498A.
Before that, Lordship, there was a amicably, it was settled that she will go from the house of this petition. They admitted, Lordship. When we obtained the certified copy of the divorce petitions, Lordship, then they admitted that they will, Lordship, leave the house of the present petitioner, and accordingly she left the house, Lordship.
And thereafter,
Thereafter, when I filed this, the Lordship, title suit, Lordship, but I have to file a suit, Lordship, for cancellation of my marriage, otherwise it cannot be cancelled, Lordship.
title suit for,
Divorce, Lordship, decree, Lordship, that is. Suit for declaration and permanent injunction, annexure 2, page 21.
what declaration is of?
Yes. My prayer is that, Lordship, for a declaration that the defendant was the legally married wife of Zakir Ahmed, son of Nijamuddin Ahmed of Goripur, so and so, for a decree declaring that the marriage. Page 26, Lordship.
Heard Miss R. Chaudhary, learned counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely 1, 2, 3, 4, 5, naam likhe bapul jata hai. Namely so and so, praying for washing of. Petitioner has been filed under section 482 petition. Praying for quashing of CR case number 100/2023 pending in the Court of Judicial Magistrate First Class, Bongaigaon, wherein the trial court has taken the cognizance of offense under section 498A IPC and has issued processes against the present petitioner. So, learned counsel for the petitioner has submitted that the respondent Uporat Korbat Likhibu, also heard Mr. B. Sharma, learned additional public prosecutor. What was the last name? Respondent number 2 was married to the petitioner number 1, Syed Atiur Haq, on. When were you married?
Lordship, the present petitioner.
Yes. Date.
Five, 6/2023, Lordship, para
5/6/2023,
3, page.
as per Islamic rites and rituals. However, comma, in the month of September 2023, the petitioner came to know through reliable sources that the respondent number 2 was already a married woman, as she had earlier married to one Zakir Ahmed, and a divorce case is pending between the respondent number 2 and said Zakir Ahmed. However, no final order has been passed in the said case, and the said case was pending before the Court of Learned Civil Judge within bracket Bongaigaon, within bracket Junior Division Bongaigaon.
Lordship, may I point out that we have information that she has withdrawn this divorce case, but I have directed them to obtain the certified copy. Lordship. So
So-
if it is withdrawn, the marriage is still subsisting. Lordship.
Learned counsel for the petitioner has also submitted that the petitioner also came to know that the respondent number 2 has withdrawn the said divorce case against Mr. Zakir Ahmed. After coming to know about this aforesaid fact, the petitioner realized that the marriage between him, petitioner number 1 realized that his marriage with respondent number 2 was void ab initio, as a Muslim woman cannot enter into a second marriage during the subsistence of her earlier marriage. And therefore, now here you have not mentioned regarding consensual living, this amicably settlement that she will be living.
Lordship.
You have
Those-
only mentioned about the filing of suit by you.
Lordship. the filing of-
But in between filing of suit by you
Lordship.
and you're coming to know about the second marriage, earlier marriage, there was an
She-
amicable
She
settlement.
left the house on
That
her
is
own.
not stated.
That I have not stated, Lordship. But it was the information, Lordship. There was a
Every-
mutual agreement,
But that has to be pleaded.
Lordship. By way of additional affidavit, Lordship, while bringing that document, I will write.
Finding no alternative, the petitioner number 1 on 22/12/2023 instituted a suit, namely title suit number 86/2023 against the respondent number 2 for declaration of his marriage with respondent number 2 as void ab initio. Stop. After filing of the said suit, the petitioner had received the notice, received the summons,
Someone, Lordship.
received the summons from the Court of Learned Chief Judicial Magistrate Bongaigaon regarding filing of CR case number 100/2023,
Page 28. Lordship,
which was
Next
filed
item.
by the respondent number 2 against the petitioner number 1 and his family member, including his mother, father, and
sister-in-law and aunt.
sister-in-law and aunt, who are arraigned as other accused persons in the said complaint case. Stop. The petitioner has submitted that the learned counsel for the petitioner has submitted that the the respondent number 2 has filed the said CR case with ulterior motive for wreaking vengeance on the accused petitioners due to the fact that the petitioner number 1 has filed the title suit number 86/2023. Learned counsel for the petitioner has also submitted that the petitioner has abused the process of court by filing a false complaint against the petitioner. The respondent number 2 has abused the process of the court by filing the false complaint against the petitioner and other petitioner number 1 and other petitioners. Stop. Issue notice to the respondents. Since respondent number 1 has been represented by an additional public prosecutor, no formal notice need to be issued to the respondent number 1. As regards the respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable on after 4 weeks at the date due. On 25th April 2024, stop. Now, stop. Considering the facts narrated in the petition and considering the documents annexed with the petition, it appears that the respondent number 2 was married before she was married to the petitioner number 1, and it appears that during subsistence of her earlier marriage, she entered into the marriage with the petitioner number 1, which is prohibited as per Islamic law. Hence, the further proceeding of CR case number 100/2023 is kept in abeyance during the pendency of the instant criminal petition number 294/2024. Stop. As this interim order has been passed ex parte, the respondent number 2 shall be at liberty to file a petition for altering the said order or vacating the said order after her appearance in this case. Let this case be listed accordingly on 25/4/2020.
Lordship, and will be given liberty to file additional affidavit making.
Counsel for the petitioner also submits that she may be given, she also submits that she requires to file an additional affidavit to bring certain additional facts on record. The prayer is allowed. When will you file?
Lordship, the divorce petition filed by the opposite party.
When will you file?
Lordship, with the, before the next date, Lordship.
Copy you have to send to the respondent number 2 also.
Lordship, then within 1 week. Lordship.
The additional affidavit shall be filed within a period of 1 week from the date of order, and copy of the same shall also be sent to the respondent number 2
Along with the notice, Lordship.
along with the notice.
Lordship, I'm deeply obliged.
I'm taking 2 minutes break.
Ma'am.
This is 439 application, Lordship, and FR page 10, operating person page 10, Lordship. Lordship, and 5.63 grams of heroin, Lordship. And there is with container to 26.10 grams.
Why it was not moved earlier? Why it was kept for?
I was.
Some-
Lordship, but rejected, Lordship. But I have
Ah.
not annexed, rejected by the.
It was rejected.
Rejected, Lordship.
Where is the rejection order?
I have not enclosed, Lordship.
File that rejection order. That has to
In
be,
the bench, Lordship, and
that is the requirement. You go through the notification. Whenever there is a rejection of bail order, while moving bail application before the High Court, you have to move all earlier rejection orders. You have to annex all earlier orders with your bail application.
I will submit, Lordship, day after.
Otherwise, it will be rejected on that ground only. So what is your prayer?
I will annex the additional affidavit, Lordship.
Heard Mr. F. Hawk, learned
Filing
learned counsel for the petitioner, who submits that the application filed by the earlier application filed by the petitioner was rejected by
Landed session just
learned session judge
Amingao Kamrup.
Kamrup Amingao. However, due to inadvertence, he could not annex the said rejection order along with this bail application, and therefore he seeks some time for filing an additional affidavit to bring on record the said rejection order.
Debtor to Lordship.
The prayer is allowed. The petitioner may bring on record the said rejection order. Let this case be listed again on
21, Lordship.
21/3/2024.
Obliged.
Item 10. Mercy, Lordship. My lord, in this case, in a malicious affair, Lordship, lodged against the petitioner, Lordship, he is in jail, my lord, for last 19 days, Lordship. FIR is kindly see at page 11, Lordship. My lord.
76. This is for the first time you are moving.
Yes, Lordship.
We'll have to go through the case diary.
My lord, before that, I may be allowed to submit, Lordship. My lord, in the FIR, my lord, it is stated before 2 years, Lordship. 2 years before, my lord, before, my lord, she had related, my lord, sexual assault, my lord, forcefully, my lord, committed by the petitioner, Lordship. My lord, in the, my lord, forwarding report, kindly see, Lordship, at page, IU has already,
When were you arrested?
my lord, arrested on, my lord, 28, Lordship, 28/2/2024. My lord. Today is 19 days, 19 days, Lordship. Kindly see.
Why your prayer was rejected by the,
My lord, prayer is, my lord, only, my lord, I have stated in the petition, my lord, but the copy, my lord.
listen to me. Why your prayer was rejected by sessions court?
Case of investigation, my lord, and,
Where is the rejection order?
my lord, it is, statement is not given, my lord,
Rejection
because
order?
of urgency, it was not annexed, Lordship.
Then I will not.
Lordship, your Lordship may have judicial, my lord, notice because this is a judicial order.
No. Urgency, you must know the procedure of filing bail application. There is a,
That is why at
there
paragraph
is a
10, I have
case,
stated.
there
Lordship.
is a case you must be knowing in Supreme Court where this practice of concealing the facts before suppressing the facts before the court is deprecated.
Not
That
for,
in this, if the prayer is, your earlier bail prayer is rejected, you are required to file that rejection order.
my lord, not concealed, Lordship, at paragraph 10, I have stated, Lordship.
Where is the,
Paragraph 10, I have stated, Lordship.
where is the order?
There's number 5 order, my lord. It is not annexed, my lord.
You
Because, my
annex-
lord,
You annex it by filing an additional affidavit.
then day after tomorrow, Lordship, I'll file
No,
additional affidavit, Lordship.
whenever you heard Mr. M.H.
Additional affidavit, Lordship.
M.H. Ahmed, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the earlier bail application filed by the petitioner before the Court of Learned Session Judge Lakhimpur, North Lakhimpur, was rejected, though earlier bail application filed by the present petitioner was rejected by Learned Session Judge Lakhimpur. However, due to inadvertence, the copy of the same could not be annexed along with the instant bail application. Hence, he prays for allowing the petitioner to file an additional affidavit to bring on record the copy
Online
of
copy,
the
Lordship.
copy of the rejection order. The prayer is allowed. When will you file?
My lord, day after tomorrow, tomorrow I'll file it.
List this matter again on 21/3/2024. In the meanwhile, the petitioner shall file the additional affidavit.
Lordship. All right.
11 and 12 similar. FIR defined. FIR of the page 10.
Why read petition?
It is barred by lordship. It is under it is registered with lordship. It's an unlawful activities prevention act. It is
So it is barred.
barred by
So there is a blockade in the highway.
43D, 43D4.
There is a blockade in the highway, therefore you have taken bypass.
So Supreme Court allowed.
But why WP criminal, my lord? In fact, if it is so, he can file a regular writ petition under 226, my lord. If this is filed under 226, but this is a habeas corpus. Normally, my lord, he has prayed for mandamus, but it is registered as WP criminal.
It should have been registered as normal
Writ petition.
writ
Writ petition. There is no prayer for habeas corpus, my lord. He has prayed for mandamus.
Application under Article 226 of
Yes.
the Constitution of India for instance of a writ in the nature of mandamus.
Yes.
For such a it is nice non-affirmative person lawsuit. Is a national level.
Now, though there is you have annexed an order of apex court that in case of UP where,
Lawsuit, I mentioned. Lawsuit.
but when in a special act, there is a bar of,
All are mentioned here in this petition.
so that has to be looked into.
Lawsuit, paragraph 6, page 5.
Yes,
So the petition.
that in spite of the bar, you can approach this court by
Lawsuit.
filing writ petitions, seeking bail.
Okay.
Where is the law?
That is lawsuit. The Supreme Court lawsuit, judgment lawsuit. Arnab Manoranjan Goswami case lawsuit.
In
So-
Arnab Goswami, whether it has been stated that in unlawful activities prevention acts case, this, you can file a writ petition seeking bail.
Lawsuit. Hema Mishra case lawsuit.
Read the relevant para on which you want to rely. Which para is helping you?
Particular not mentioned this act.
No, Mr. Gogoi,
Lawsuit.
I want to understand why have you cited Arnab Goswami's case? How it helps you?
Lawsuit.
How it helps you in your case?
Supreme
In your
Court said-
case, the allegation is under Unlawful Activities Prevention Act that in the name of Alpha, some money was extorted.
Lawsuit.
So you are saying that though in Unlawful Activities Prevention Act, there is a bar of applicability of section 438,
Lawsuit.
you can file a writ petition.
Lawsuit. So the fixed committee at 2 lawsuit. I will give all details.
Okay. That's, or Mr. Nath, you can help.
But in Arnab Goswami case, I have seen there, Honorable Court has discussed that it is bail, not jail. That is the principle court has discussed, but not on unlawful activities act. And I have checked, Mulad, that
He has cited one more case.
one more, that is, Mulad, all the three cases.
The
Mulad,
third case, the
Third
third
case.
case, Hema Mishra's case.
Hema Mishra is under section 419 and 420 IPC. Principles relating to grant of bail is there. These things is not discussed in all the three cases. I have not seen. I have seen all the three cases.
Hema Mishra's case may help you.
Yes.
You go through both of them.
I'll say.
We'll take it up at 3. No, at 2.
At 2, the court 1 is sitting law.
At 3.
3.
At 3 p.m.
Lots.
Item 19.
Well, also. The petitioner is alleging double eligibility matter issued by the additional judicial magistrate matter, page 26 matter. And all subject matter. Page 26 matter, order dated 1/10/2018. NBW district matter, without swing under variable matter.
On which date NBW was issued?
1/10/2018,
1 day, okay.
page 26.
Why you were absent without?
But the petitioner has no knowledge about the filing of the case. He is staying outside in Kerala. He has no knowledge about filing the FIR or even filing the substitute. And
So when you came to know,
first week of February, when my lord, notice of my lord,
how you came to know?
no, notice of my lord, PNA was affixed in my locality. First week of February. And I will go, but I will appeal for the court matter. Even when the FI was lost, my lord, after more than 4 months.
What is the last order?
Last order, my lord, dated 1/12/2018.
Thereafter,
Final dismissed.
The case has been filed.
Case has been filed. On 1/12/2018. A notice was affixed, my lord, in my locality. First week of February, my lord, 2022.
How it can be when it is filed in the year
Well, extending
2008?
my lord, NBW was still like this, my lord.
But the notice has to be fixed before 2018,
My lord,
before the case was fixed.
my lord, last week of February, one notice was issued, affixed, my lord, in my locality.
in between what happened?
Then
That's
either
what
you
I-
are not properly instructed, wrongly instructed by your client. Because when the case has been filed in the year 2018,
My lord.
it has to be after
As
period.
per my instruction of my client, my lord. he came to
Instructions
know, my
are
lord,
wrong,
my lord. He came to know that, my lord,
or he is not telling lie,
Yes, yes.
speaking, he is not speaking truth to the court.
Instruction is not proper, my lord,
Because
I think.
case was
it
filed
was
in
filed in
the
the year 2018.
18.
18.
So notice has to be fixed
In the year 18.
before that filing of
Before
the,
1/12/2018.
yes,
Should be, my lord.
it
My lord,
cannot be
according to
after.
my instruction, my lord, he came to know that, my lord, notice was affixed in his locality, my lord, first week of February.
So you should have asked your client, because you know the law, he may not know the law. Notice can,
He was outside his, my lord, he's
No.
staying at, my lord.
therefore I am asking how you came to know,
18 or
why
54
you
order.
came before this court in the year 2023?
And that's my instruction, my lord, it's my instruction.
You don't take proper instruction.
Even though you're also under pass order, my lord, writing the petition.
Yes, this court can pass order, but you have to make fair submissions before the court.
And that is my instruction. That's my lord.
Because client may instruct whatever they think, but you have to make submissions before the court. So therefore you have to take proper clarifications. After 2018, there cannot be a fixing of notice. He might have come to know when police went there to arrest him and did not arrest him because of, I don't know whatsoever reason.
18 or
My lord,
24.
this report, my lord, reveals that, my
Where
lord,
is where is the statement when you came to know about the,
my lord, para, my lord, 7, my lord. Page 18, page 7, my lord. Para 7, page 7, my lord. That's a relevant question, my lord. I have not mentioned a date, my lord, explicit date, my lord.
you have not mentioned it.
But the first, when I told my instruction is, my lord, February 1st week of February.
Heard Mr.
Khonikar, my lord.
A. Khonikar, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, Command 1973, has been filed by the petitioner, namely, what is the name? Kaulia Bhuya, alias Purnakanto. Kolia Bhuya, alias Purnakanto. Praying for, impugning the order dated 1/2/2018, by which the PRC case number 1/12/2018 passed in PRC case number 104/2018, whereby the Court of Learned Additional Chief Judicial Magistrate had issued standing non-bailable warrant of arrest against the present petitioner, and the PRC case number 104/2018 was filed till production of the petitioner before the said court. Stop. Learned counsel for the petitioner has submitted that though the case, that is PRC case number 104/2018 was filed by the Court of Learned Additional Chief Judicial Magistrate, Dhemaji, on 1/12/2018. The petitioner, came to know about the pendency of the said PRC case only in the month of February 2024. And he also came to know that a pending warrant of arrest has also been issued against the present petitioner. It is submitted by learned counsel for the petitioner that the petitioner is willing to cooperate, willing to appear before the trial court and cooperate in his trial. And he may be given interim protection so as to facilitate him to appear before the trial court. Stop. Considering the submissions made by learned counsel for the petitioner, as well as considering the materials available on record, the petitioner is hereby directed to this criminal petition is hereby disposed of with a direction to the petitioner Kolia Bhuya alias Purnakanto to appear before the Court of Learned Additional Chief Judicial Magistrate Dhemaji within a period of 15 days from the date of this order and cooperate in his trial. Stop. To facilitate his appearance before the said court, the operation of standing bailable, non-bailable warrant of arrest issued against him by the Court of Learned Additional Chief Judicial Magistrate Dhemaji shall be kept in abeyance for next 15 days. Stop. After his appearance before the said court, the petitioner may make any such prayer, may make prayer for any such relief before the said court to which he is legally entitled to. With above observation, this criminal petition is hereby dismissed. You have to take proper instructions from your clients.
Item 20.
My lord, inadvertently, my lord, one translated page of Annexure 3 is not annexed, missed to annex, my lord. So I'd like to withdraw this petition with the liberty to file a fresh.
Heard Mr.
H.R. Chaudhary.
H.R. Chaudhary, learned counsel for the petitioner, who submits that due to some inadvertent error he intends to withdraw this instant criminal petition with a leave to file afresh. Considering the submissions made by learned counsel, the prayer is allowed. This criminal petition is disposed of on withdrawal with leave granted to file a fresh petition if so required.
Item 21.
Yeah, please, Your Lordship. Lord, this is succeeded case, Lordship, child praise. Petitioner is the father of the victim, Lordship. Lord, this is Lordship.
Charge sheeted case.
My Lord. Your Lordship may call for a scan copy of the case record, Lordship.
This is anticipatory bail.
My Lord.
So in charge sheeted case, you were issued summons by the trial court.
No, yeah, summons is not yet received. Charge sheet is filed, Lordship. I have an exact charge sheet.
Then why are you apprehending your arrest?
But obviously, because POXO case is registered against me and charge sheet is also filed against the under POXO, Lordship, against the present petitioner. In fact, Lordship, his name is nowhere mentioned in the FIR, Lordship. There is no.
But in charge sheet, you are a
Charge sheeted.
charge sheeted accused.
My
Charge sheet is filed against how many accused?
my Lord, against Lordship, three accused, Lordship. Husband and father of victim and father of husband, Lordship. Page 18, Lordship. Start for 15. Your Lordship, call for a scan copy, Lordship.
No, question of calling scan copy does not arise. First of all, whether your anticipatory bail application is maintainable now,
Because there are, Lordship,
because summons have not been issued. There is no bar
my
on
Lord,
the court for
yeah.
now. Legal bar is not there
Yes,
for
yes.
not granting
Lordship,
bail.
can it be taken over with the Lordship? I only offer instruction whether someone is issued or not.
Okay. On prayer of heard Mr.
M. Khan.
Heard Mr. M. Khan, learned counsel for the petitioner as well as Mr. B. Gogoi, learned additional public prosecutor. On request of Mr. learned counsel for the petitioners, let this case be listed again on 20th of March,
My Lord.
20 March,
My Lord.
2024.
Problem.
Item 22.
May please, Lordship. But for 38 bail application, my lord. My lord, allegation brought, my lord, in FIR page number, my lord, 11, my lord. 1 year, 6 months back, my lord, the petitioner was committed rape. And thereafter another allegation brought, my lord, before 3 months when the offense was occurred. And only because of, my lord, covering the limitation, my lord, on 14/11/2023, my lord, the petitioner was whispered in the outside of the room of nearby the victim, my lord. And he approached the matter to the father. And father uses slang language. That is why filed the Azahar on 15/11/2023, my lord. My lord, before 1 year, 6 months that
Where is
rape
the-
was committed, no Azahar was lost. Before 3 months, the matter again occurred, no Azahar was lost. Only on 14/11, my lord, covering the limitation that the
No, there is no
petitioner
limitation
whispered
for,
outside the room.
is there any limitation period for filing?
FIR please 17.
Informant's husband Joseph Ali, Lordship, and petitioner's father is Intaz Ali.
Okay, now what has happened?
Lordship, what happens from 2021, there is an old rivalry between the petitioner's family as well as the informant's family. The page 23 is the FIR dated 22/09/2021, when the petitioner's brother has lodged an FIR, Lordship. Lordship, may I read the vernacular one, Lordship?
No,
Page-
first you narrate the story.
Lordship,
Then if
the-
required, you have to read.
Lordship, file an FIR against the
438 and 439. No, they got it.
Yes, Mr.
Yes.
Gugoi. The co-accused have been
Co-accused has
granted.
already been, yes. This
Heard-
is 438, that's why I make this query, whether 438 or
Heard
439.
Mr. T. Sutia, learned counsel for the petitioner. Also heard Mr. B.B. Fukon, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Muhammad Ismail Ali, who is apprehending his arrest in connection with Boshishto PS case number 71/24 under section 379 of the Indian Penal Code, read with section 11 within bracket 1 within bracket small d of the Prevention of Cruelty to Animals Act 1960 and section 13 within bracket 1/16 of Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on 5/2/2024, one Rituporno Kolita, SI of Police of Jorabat Police Outpost lodged an FIR before the officer in charge of Boshishto Police Station, inter alia, alleging that on that day at about 4 a.m., your vehicle number is,
AR02CC 9967, Lordship.
and the other vehicle number
Other vehicle number AR01NC 6952, Lordship.
that is not mentioned in the FIR.
Mentioned in the FIR, Lordship.
Where?
Yes, Lordship, a page, FIR, Lordship, find a page. Lordship. Page number 12, Lordship. Second page of the set of the FIR, Lordship. Or is not, Lordship, Lordship, the first page of the FIR, Lordship, first portion of the FIR.
Last line, yes, sir. 4 a.m., two vehicles, namely AS02CC 9967 within bracket Bolero pickup vehicle loaded with 13 numbers of cattle and another vehicle bearing registration number AS01NC 6952 was loaded with 23 numbers of cattle were seized, and it was suspected that the cattle carried in the said vehicles were stolen, and as well as they were carried illegally in violation of the provisions of law. Stop. Learned counsel for the petitioner has submitted that the petitioner is not the owner of the cattle which were seized on 5/2/2024. However, he is the registered owner of vehicle bearing registration number AS02CC 9967. It is also submitted by learned counsel for the petitioner that a coordinate bench of this court in AB case number 380/2024 by order dated 19/2/2024 has already granted bail to another co-accused, namely Moidul Ali, who is the owner of the other seized vehicle, that is vehicle bearing registration number AS01NC 6952, as well as he was also the owner of the cattle seized in the case. It is submitted by learned counsel for the petitioner that the petitioner is ready to cooperate with the investigating officer, and as the co-accused has already been granted an interim protection by a coordinate bench of this court, he may also be granted the said protection. Stop. On the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary. Hence, call for the case diary fixing.
My lord, that 27.
In that case,
That
what
case, Lordship, it was fixed on 15th, Lordship. On that day, case diary was not received, Lordship. So the matter was adjourned for 2 weeks. After 2 weeks.
That not fixed.
That fixed.
Then my lord, might be come in the first week. That not fixed.
give it 4th of Sabbath, basically.
15 তারিখে যখন তার হলে
Fixing 4th of April 2024 for case diary. However, in the meanwhile, as the co-accused has already been granted interim protection by a coordinate bench of this court, the petitioner, namely Ismail Ali, is directed to appear before the investigating officer of Boshishta PS case number 71/24 within a period of 15 days from the date of this order. And date to all of Piswaiduk. 23rd. Within 15 days from the date of this order. And cooperate in investigation. Stop. If he does so within the stipulated period, in the event of his arrest in connection with Boshishta PS case number 71/2024, the above named petitioner shall be allowed to go on interim anticipatory bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with a condition that he shall cooperate with the investigating officer. Let this case be listed again on 23rd of April.
Well, I'm sorry, my lord. In this sector of item number 40, my lord. Well, I have talked with SC Kyle, standing counsel, well, and here. Well, no case diary received. I have just talking. So, another.
Item number?
Item number 40, Lordship. Allow us stay in this time.
Right.
Third, Mr. A.K. Hussain, also heard Miss M. Deka,
Yes, Lordship.
learned counsel for the
DRI, Lordship.
DRI, who prays for some more time for producing the case diary.
Yes, Lordship.
Prayer is allowed. Let this case be listed again on
After 10 days.
3rd of April. 3rd April, class.
Ma'am,
Okay,
Third
yes,
of
it is open there. Yes, Lordship, Alok Kumar, Lordship. That was listed today. CD has been received, Lordship, by the IO of Delhi, Lordship. 16 big volume, Lordship. May I prefer, Lordship, to kindly take up this letter by tomorrow, Lordship.
But this case will be notified again.
Yes, Lordship. That is the difficulty. 16 volume has already been brought today, Lordship.
When do you want? Tomorrow?
Tomorrow, Lordship. Tomorrow at any time, Lordship. But, it will be, Lordship, very.
You have informed Mr.
I'll inform Lordship.
Mr.
Arguments were concluded only the CP party is there.
What was the name of the council for the other side?
He was from
S.
Delhi.
Man, Sanjay
Man,
Man,
yes,
Mr. Man.
Man.
You have to inform them.
Yes, his junior is from Guwahati, I will inform him.
Then let it be a day after tomorrow.
Day after tomorrow. I don't know, I don't know whether he'll be staying here.
Okay.
Tomorrow he'll be staying, Lordship.
Okay. Then you inform Mr. Man
Yes, yes, surely.
on request of Mr. M. Haloy. Your name? This is item number?
18.
No, it has not come in the list. You have to give a mention on,
Okay, I'll give Lordship.
because
I'll
a
give-
notification has been issued that
Right.
these matters are deferred.
Yes,
So record has not been sent by registry.
Lordship, I'll give a mention.
Give a mention memo, it will be allowed.
Lordship.
Come on.
I'll leave.
May it please your lordship. Madam, the petitioner has been herein charged with 342, 376 IPC along with section 4 of the POXO Act. The witnesses were examined. During that time, my lord, he was in the jail custody. Therefore, he could not properly advise his client, his lawyer, to cross-examine. Therefore, he filed an application under section 311 of the CRPC for cross-examining, recalling those witnesses and for cross-examining. Page 39, your lordship will find that application is there. And page 42, 44 is the improved order. Page 39, if your lordship wishes to see.
Your prayer was rejected.
My prayer was rejected on the ground that the grounds that he has cited does not merit consideration. Paragraph 7 at page 44. I have considered the submissions made by the learned counsel for both these sides. However, the grounds on which the learned counsel for the accused has sought to recall the prosecution of witnesses under section 311 does not merit consideration. He has not discussed anything. That is the thing. As to why it will not be necessary. Because ultimately,
Reasons are not mentioned.
reasons are not mentioned. That's simply by saying that it does not merit consideration. That will not do.
Which for the
Other side.
The POXO matter, informant has been arraigned as party. Lordship, matter may be fixed for consideration on a particular date, my lord. My learned senior friend is saying it is fixed for tomorrow. The trial.
you have saved the cost of litigation, or you have burdened your client with cost of High Court's litigation.
No.
Had you approached the magistrate court, you would have got two forums. You could have come to Sessions Court. Suppose this case, in this case, you don't get any relief. High Court rejects your prayer. You cannot go to Sessions Court. Neither you can go to Magistrate Court again. Had it been otherwise, you would have the option of approaching the High Court. But, okay. But as there is no legal bar, we are issuing notice. We are calling for the case diary.
But in this case, your lordship, if your lordship will go through the FIR, your lordship, is 9. The whole allegation is against the two persons. One is Indrajit Das and another one is Fazlul Karim. Nothing is against the present petitioner, your lordship. His name is not mentioned. And in the forwarding.
No, but this case has not been considered by any other court at earlier stage. So we have to consider the case diary as to what is there in the case diary. Heard.
But in phase 10, your lordship, what materials they have seized, your lordship, from me? Some mobile and one motorbike, your lordship, have been recovered. Except this, nothing they have recovered. your lordship. In
No, that is not true, my lord. Your lordship, please peruse the page 10, my lord. Ground number 2.
Heard,
During investigation, several incriminating documents recovered from the house of the accused.
heard Mr. A.M. Khan, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure has been filed by the petitioner Mohibul Sikdar, who has been detained behind the bars since 4/3/2024. Stop. Considering the nature of allegations leveled against the present petitioner, the perusal of case diary would be necessary, hence call for the case diary.
2-4.
Fixing 2/4 for
Your
case diary.
lordship, if it is possible on 28, your lordship.
From
I
Goalpara.
would have given a longer date. 2/4.
Obliged.
Item 25, photo operating.
My lordship, kindly see, my lord, page 8 is the affair, my lord. Very small affair, my lord. My lord, this affair has been lodged by the brother of the victim, my lord. May I read, my lord?
Yes.
My lord, sir, with due respect, I beg to state that on 14/2/2024, my minor sister, namely so-and-so, aged about so-and-so, accompanied by her friend Dondi Sangma, went to the village of Sadbhuni Sandamari for attending in a marriage ceremony. They met the below named accused person in the marriage venue. The accused person known to Dondi Sangma. At about 9 p.m. at night, the said accused person picked up my sisters in a car by way of inspiration by saying to leave them in the house. Thereafter, they were drank intoxicating materials within the car forcefully and then taken to Ambari burial ground and got down from the car there. Thereafter, they touched the private parts of my sister with a view to commit rape upon her but my sister somehow saved herself, escaping therefore. This is the my lord affair, my lord. Yes, my lord, your lordship, kindly see the incident took place on 14th. Affair was lost on
No,
18th.
it is the POX. Whether
He is the informant, my lord, here in this case, my lord.
Very specific, my lord.
what it says,
354B, assault or use of criminal force to women with intent to disrobe. Any man who
Okay.
assaults or uses
only man is there.
So my lord, this 354 is not attracted. So two section remains, my lord, 379, that is theft, and 67A IT Act, which speaks about publishing or transmitting material containing sexually explicit act. But my lord, police, my lord, the officer in charge, when my lord registered the case, this section was not, my lord, case was not registered under section 67A. But in the form, my lord, lordship will find that at page, my lord, 21 of my petition. Received and registered, lordship got it?
Yes.
Received and registered dispute PS case number so and so under section 341, 323, 356, 379, 325, 354B, 427, 342 IPC. Only these sections. But in the, my lord, FIR, my lord, form, my lord, page 14. There, your lordship will find 67A of the ITF. But my lord, our specific stand is that, my lord, we have not, my lord, I have not, my lord, made any, my lord, I have not done any publishing or transmitting material containing sexually explicit act, my lord. So here, your lordship will find the FIR at page number 11. May I repeat, lordship?
Yes.
With due respect, I beg to state that I, so-and-so, wife of so-and-so, residing as a tenant at so-and-so on 12/2/2024, as per the instruction of my husband, I went to the house of one Runjun Bora, resident of so-and-so near Pratiksha Hospital, to pay a sum of rupees 20,000 due to said Runjun Bora. So this is the petitioner, lords. Runjun Bora confined me inside her house, thereafter started assaulting me and snatched away cash amount of rupees 30,000. Here, my lord, the FIR, she went to give me 20,000 and allegation is that I have snatched 30,000 from her. Runjun Bora caused grievous hurt on my head with a beer bottle. As a result, cracked my head. She, after torning my clothes, video recording of my nude body and showed to my husband, so-and-so. Then I came to know that this incident happened due to the criminal conspiracy hers with my husband, so-and-so. The video of my naked body was also viral. My mobile phone was also totally broken. Runjun Bora has been assaulted me and thereby caused grievous hurt by
the page 15. And my lord, what is my humble submission, my lord? On the same footing, my lord, the coordinate bench has granted bail, my lord, that I have annexed page 30 and 33.
Bail to whom?
Page 30 and 33.
My lord, that is also after use of the scan copy, my lord.
So, my lord, my submission, my lord, I may be allowed to appear before the learned trial court and will cooperate with the trial, my lord. I may be allowed to appear with any condition, my lord, so that my trial may be proceed and the person who was arrested, his trial.
Then let the trial court decide your bail
My lord,
application.
my lord,
My lord,
I'll give a direction, you appear before the trial court
my lord.
and trial court will consider.
Consider as per, my lord, merit of the law.
my lord.
Till then, you will not be arrested. Till your appearance before the trial court.
My lord, here in this case, the page number 30 and 33, the two orders I have annexed. In these two orders, my lord,
The trial has begun.
trial not begun.
Charge sheet has been laid.
Charge sheet date,
Charges are framed.
not framed,
At what stage it is pending?
just on production stage,
The trial court has issued summons to you.
not issued yet.
What process has been issued?
Process, my lord, just charge sheet was submitted and charge sheet was submitted, my lord. And no, the summons is not issued yet, my lord. It is only in, on, my lord, appearance stage, my lord.
Then why are you apprehending arrests?
Apprehending, my lord, my name is in the charge sheet.
There's an absconder, my lord.
Mine as an absconder.
As an absconder?
As an absconder.
What order coordinate bench has passed?
My lord, kindly see page 30. Page 30 and 33, the two orders, my lord.
They were also shown as absconder.
Absconder.
That is also, my lord, page 32, my lord.
No, that relief I am also.
My lord, that is the lordship.
That was, it was on appeal.
Not finally disposed of, my lord, it was.
On my lord, on page 32, the condition was imposed.
No,
by
it is only for interim death part, my lord. Till his appearance, my lord. Till his appearance, my lord.
Page,
Earlier, my lord, directing the applicant to appear before the learned special judge so and so on or before so and to apply for regular bail. And in the event of filing such an application, the learned court below shall consider the same in accordance with law.
And para 9, my lord, the conditions were given.
It is for interim matter.
You have privilege, however, subject to the following conditions.
That conditions are imposed only for the period, my lord. It is appearance, my lord.
But no bail was given.
My lord.
Remain, my lord, page 33 also.
That is similar, my lord.
In page 35, my lord, kindly see on executing bail bond of rupees 50,000 only. Page 35, my lord. Para 8.
But in page 34, as regards in para 4,
My lord.
Yes, ma'am.
you have mentioned that the trial court has issued non-bailable warrant. of
My lord,
arrest.
that is why, that is
In
why.
that
my
case,
lord. That is different, my
that
lord.
case.
And in against the present petitioner, no processes have been issued.
My lord.
How it can be?
So, my lord, bail bond maybe your lordship.
No,
may
no,
impose
No,
by-
no, it is
First you make the
NBW.
facts clear.
Hmm.
You are saying that there were 3 accused persons. Against 2 accused persons, court have issued non-bailable warrant of
Warrant.
arrest.
Right.
Against you, no processes have been issued.
No, my lord. In my case, my lord, one person have been arrested and I have been absconded. NBW was not issued yet. Summons was not issued yet.
And this case is a different case.
This
My
case
lord.
a different case, my lord. This is a different case, just in similar cases, my lord. Coordinate when granted bail, my lord, in this way. So, my lord,
So
for
in this case, there was an apprehension because non-bailable warrant
Non-bailable.
was there. In your case, there is no
No.
such apprehension.
apprehension, my lord, I am showing as an absconder, my lord. So I may be arrested in any times, my lord. Any times I may be arrested. Because in a case where I have been implicated, there is a apprehension, my lord. So I am absconding here.
No.
You surrender before the trial.
My
court.
lord. Within 10 days, my lord.
And my lord, and a condition, my lord, a bail bond of condition.
No,
I will,
that is-
I surrender. I'm going to surrender, my lord.
Condition of bail bond will be
Decided by the
applicable
court below.
only if you are granted bail. You need not to furnish bail bond unless you are granted bail.
My
So-
own appearance, my lord. On appearance, my lord, the bail may be granted with some condition, my
No,
lord.
no, that is not
On
the
appearance.
direction, my lord, of the.
Your
High
lordship may observe it
That
this way, my
trial
lord.
court will
So
decide.
my lord, at least my apprehension will go, my lord. then.
This is a commercial.
Commercial quantity, my
right,
lord,
my
commercial
lord.
quantity.
But
During investigation, he
there
is
are-
not,
there are-
my lord,
This is
cooperative,
right, my lord, but there are some
not
judgment, my
cooperative
lord.
during the investigation, my lord.
As there are some judgment is also there, nothing recovered from me,
That is
nothing
not
from my
right, madam.
possession. So 67 is not a basis to, my lord, to implicate me, my lord. On the basis of the interrogation and statement of the arrested accused persons. Whether in such footings I
Do
may
you
be.
satisfy the trial court?
No.
Trial is
So
pending.
this is right, my lord, your lordship may.
Heard
consider the
Mr.
Condition, my lord.
Heard Mr. H. R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application has been filed under section 438 of the Code of Criminal Procedure, 1973 by the petitioner apprehending his arrest in connection with special NDPS case number 100/2023 arising out of Nilam Bazar PS case number 140/2023 under section 21C/25/29 of the NDPS Act, 1985. The gist of accusation in this case is that on the basis of an FIR lodged by one
SI Devjyoti Malak.
Where is the affair?
FIR page 15. Page 16 is the last page, my lord.
Affair SI Deepjyoti Malakar alleging recovery of how much total weight of heroin was? Recovery of 768
grams.
grams of heroin from the accused persons who are named in the FIR involving the present petitioner. An investigation was initiated and ultimately on completion of investigation, charge sheet has been laid.
Cut.
Where is the charge sheet?
My lord, page 21 is the charge sheet.
Charge sheet
Charge
has
sheet
been
was laid on 31/12/2023.
31/12/2023 against how many accused persons? Three.
There are total 3 persons.
Three accused persons
Three accused
involving the present petitioner under section 21C/25/29 of the NDPS Act. Stop. The name of the petitioner has been shown in the charge sheet as an absconder.
Page 23, my lord. Page 23, he is shown as absconding, my lord. Page
As an
23,
absconder.
my lord.
Stop. Learned counsel for the petitioner has submitted that though the trial court has yet to issue any processes against the present petitioner, however, as the name of the petitioner has been shown as an absconder, he is apprehended that he may be arrested in connection with this case. It is also submitted that no recovery has been made from his possessions as alleged in the FIR as well as in the charge sheet.
Page 16 is the FIR, my lord. Interrogational statement. The basis of interrogational statement. Page 16, second paragraph.
Learned counsel for the petitioner has also cited two orders of the coordinate bench of this court passed in AB case number 3669/2023 on 6/12/2023, as well as in AB case number 4730/2023 passed on 22/1/2024, wherein under similar circumstances, the petitioner of those cases were granted interim protection by the court. Stop. Learned additional public prosecutor, on the other hand, has submitted that as the trial court has yet to issue any process, there is presently no basis for apprehension of arrest by the present petitioner. It is also submitted that the contraband involved in this case is of commercial quantity. Hence,
Objection, then. My objection.
hence the embargo of section 37 would be applicable in this case. Stop. Since as per the submissions made by learned counsel for the petitioner, the trial court is yet to issue any process against the present petitioner. This court is of considered opinion that this anticipatory bail application may be disposed of with a directions through the petitioner that he shall appear before the trial court within a period of 15 days before 15 days of this order, and shall pray and may pray for regular bail before the said court. And in the event of filing such an application, the trial court shall consider the same in accordance with law. Stop. You appear now
Within 15 days.
in between these 15 days, there is no apprehension of being arrested. Do you have any apprehension
Yes, madam.
in between these 15 days? How, on what basis you will be arrested? There is no NBWA. You make me understand.
My lord, since my lord, in charge sheet, my lord, I have been shown as an absconder, my lord.
So what I am saying, let you appear before the trial court and trial court will decide. No further protection is required. With above observations, this anticipatory bail application is made by this.
On filing my bail application, my lord.
No,
bail
that is
application-
direction cannot be.
This I have mentioned.
My lord.
It will be decided according to law.
No, my lord.
Please.
Item is at 3 PM, item number 11.
Mr. Nath is there.
What happened?
All of piece of not time. We'll call it after some time.
Item 28.
Four 38 application lordship, similar to earlier case lordship, but here my case is little different lordship. Here your lordship will find page 10 is the FIR. Here two FIR named persons were apprehended along with the contraband. And now my involvement, your lordship may kindly see in the charge sheet, just I'm placing for your lordship. Page 24. Page 24, second paragraph, lordship may kindly see. During investigation, that part, lordship, what?
Yes.
Yes, 24.
24.
Yes.
During investigation, the FIR name arrested accused, namely Jewel Hussain, revealed in his statement that he was sent by one Kaji Gulam Mustafa, so and so, district so and so, to go with the driver of the vehicle bearing registration number so and so, namely Parvinder Singh. The ganjas and liquid rubber were loaded at Khairpur, Agartala, in a rubber factory with the help of some labor. Accordingly, I took the arrested accused Jewel Hussain to Tripura Port to identify the place of loading and identify the other co-accused. But while rushed to rubber godown factory, the factory was found closed. So other accused could not identify. In this regard, drew a sketch map on the loading place. So this is my involvement. That a co-accused named me, that I have sent him to the along with the truck. But here he has not said that whether those contrabands belong to me, whether I have that knowledge or not. Those things are not mentioned here. And my apprehension is that lordship against me, lordship.
Here charge sheet has been laid.
Charge sheet has been. I have the material which I have placed before your lordship. This is the material of charge sheet. In the FIR, I am not named. And just on lordship, 7/12/2020, NBWA issued against me. Therefore, I have apprehension that if I go there, I will be put behind bar. Lordship. My limited prayer, lordship, that I may be protected for 10 days. I will appear before the trial court. Trial court will decide as per law, lordship. Only that limited period I may be protected.
Just I am handing over to Lordship copies of coordinate bench order, Lordship. On interim, they were protected. Considering the fact that therefore nothing were recovered from their position, Lordship. Just Lordship, and this is the first order I have given. In second page, your Lordship will find that observation. He was protected for 10 days. With a direction to appear.
No, no,
before the-
why this protection for 10 days? You may be.
Because
afforded.
NBWA is there. Lordship.
Why NBW was issued?
NBWA, Lordship, someone
You
was.
did not honor the summon, therefore NBW
So
was.
someone was not properly served. I have that certified copy of the dot order, Lordship.
So you want an interim bail?
Interim protection. Interim protection for 10 days, I will within
So
that.
for this interim bail, whether 37 would be applicable for interim period also?
For interim, Lordship.
You have to satisfy because if bail is prohibited, interim bail is also prohibited.
That,
That you have to make me understand, because
is
my
the-
idea is that if you cannot get the main relief,
Lordship.
you will not be getting the interim relief also.
That I understand. Because I'm just only relying that first order which I have changed. For that.
You appear before the trial court without any protection.
In that case, it will be difficult. In that case, Lordship may call for the record, Lordship, that I will submit on mail.
Okay.
Because then in that case, I can go for in view of the Tufan Singh's order also. Then therefore, I'm saying that record may be called
What
for
to fund things order?
Tufan Singh's judgment, Lordship, constitution based of Honorable Apex Court that coordinate the co-accused statement cannot be relied on. And recently that Honorable Supreme Court, another case, Lordship,
Okay,
directed.
then you can submit on mail.
Yeah, yes, Lordship. That therefore record may be called for.
Yes, heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 4, you have taken that plea
Yes, Lordship. That nothing
That
was
he-
recovered from his position that
and
he has
he is,
taken.
he has been made an accused only on the basis of
Co-accused.
statement
That
of-
is there. That is
what was the last name? 438 of the Code of Criminal Procedure has been filed by the petitioner Qazi Ghulam Mustafa, apprehending his arrest in connection with Bazari Sera PS case number 185/2022 corresponding to special NDPS case number 151/2022 pending in the Court of Learned Special Judge Karimganj. Stop. Learned counsel for the petitioner has submitted that though non-bailable warrant of arrest has been issued against the present petitioner, the summons which were issued to the present petitioner were not properly served. Stop. It is also submitted by learned counsel for the petitioner that though no recovery of any contraband has been made from the possession of the present petitioner, he has been implicated in this case only on the basis of the statement of the co-accused, and as per the submissions made by learned counsel, same cannot be relied upon in view of the judgment of the apex court in Tufan Singh versus
Union of India versus Tufan Singh. I will give the citation. Lordship.
citation you have to give.
I will give you.
Stop. In view of the submissions made by learned counsel for the petitioner, perusal of the scanned copy of the case diary of Bajari Chera PS case number 85/2022, as well as scanned copy of the NDPS case number 151/2022 would be necessary for consideration of the instant bail application, hence call for the same registry to take steps for requisitioning the aforesaid scan copies. Let this case be listed again on 19th April 2000.
Lordship, can it be on 22, Lordship?
On 22 April.
Hablar.
29.
May I please, your Lordship? Lordship, 438 bail application. FIR at page 10 kindly find. Relevant portion page 12, my lord. May I read, my lord? With the due respect.
Allegation is under 307.
My lord,
Arms Act
307
is also there.
And
Arms Act also
Arms
there.
Act 25, 1A, my lord.
Lordship, may call for CD, my lord.
Case diary would be
My
required.
My lord, in this case,
Only
in the
CD.
FIR itself, it has been revealed that some land dispute in between the parties was going on. And as my lord defense, I have stated in my various paragraphs that due to my lord conspiracy to trap me in a false case, they have lost this FIR, my lord. And they have also stated in the FIR that land dispute is there. This is the fact. And
No, land dispute may be there
Fire-
as a fixing. Which date?
my lord, in the meantime, I may be protected.
No, no, my lord,
Sure.
it's not
Maybe
at this
they
time, my
will
lord.
give-
4th of my lord, 4th of April, my lord.
4th of
4, 4.
April.
What?
4, 4, my lord.
Fixing 4th of April for case diary.
4, 4.
Yes.
This husband directly not said this act, on this act. If the husband-
Then we will issue notice.
Lordship, I have a two case of our high court. Lordship. Similar cases.
কোন কেইটা এই হেৰি কেইটা এই যে ধেমাজি হেৰি কেইটা নেকি ধেমাজি কেইটা কোন ৰাজু চেতিয়া নেকি ৰাজু চেতিয়া
No, but you have cited 3 judgments in your petition.
Lordship.
Whether any judgment helps you.
Lordship, in this case, Lordship says that Lordship can entertain 226 of Constitution of India for protecting.
ইয়াত তোমাৰ পুলিচৰ against
protecting of
allegation
accused.
Under 226 also bail can be granted.
Lordship, interim protection.
Yes, Mr.
But here kindly give us 1 week time so that let me have the instruction. Kindly see the FIR was lodged in the month of August 23 at page 10 NHR 1. And my lord, the offense is very serious and now after a long period and my lord, in the petition there is no such just
That it is not true,
it is not true.
only denied.
That is the denial.
So, perusal of the case diary, even if you treat,
Lordship,
But
this is not a FIR named person. Lordship,
maybe, because nobody has been named in the FIR.
Yes, Lord. For the purpose of
And you have prayed for quashing of the FIR also.
Yes.
On what ground? Because FIR does not have any defect. The
Case has been
FIR,
registered.
the case has been, the cognizable offense has been disclosed.
Yes, my lord.
main accused person already arrested. He's not said anything in his forwarding report. The forwarding report
This includes here, but
Forwarding report may not be, but Lordship may give us some time.
Then
so that-
why are you apprehending?
okay.
Why are you
Police
apprehending?
going to my room, Lordship, therefore. Only that shows us.
No, then
Till there no positive action shall be, then I will appear before the IO, Lordship.
But
I
Lordship
recorded
may,
my statement.
at this stage, Lordship may give me 1 week time. Let me have the instruction. And Lordship may keep the matter after a week.
let them take instructions.
Yes, yes.
Heard.
I may to allow
No.
to appear before IO, Lordship. No positive action shall be.
No, no, that will amount to interim order. My lord. In fact, my lord, in Hema Mishra case, my friend has, learned friend has mentioned, in Hema Mishra case, Honorable Court has said in paragraph 27, although it is a concurring view, my lord, Honorable Court has said that while exercising the power under 226 court, definitely Honorable Court can
Grant bail also.
grant interim order also. It is said in para 27, my lord. In fact, para 21 and 27. But the court has said, court has said that the power has to be very cautiously used.
No, the Hema Mishra says that where 438 is not applicable,
Lordship,
under 226 also
can be,
anticipatory bail may be granted.
yes, my lord.
That is the, but that observation is made in case of an IPC offense,
IPC offense
Not-
and not unlawful.
UAP offense.
EAP. And that apart, even if, my lord, assuming that the 226 under 226 act, the power is to be exercised, then it has said that very cautiously it has to be used and considering
Sparingly.
consider sparingly and considering the materials and the grounds stated in the petition. So at this stage, I will pray, my lord, give me 1 week time, let me have the instruction because cases are very old.
The FIR is on.
FIR is on August,
Okay.
page 10, 30th of August 23. And
Now police disturb me. Earlier time not disturb. Therefore I am coming. Lordship.
In item number 11. Heard Mr. L. Gogoi, learned counsel for the petitioner. Also heard Mr. D. Nath, learned government advocate,
Lordship.
Assam. This writ petition, criminal has been filed by the petitioner Utpal Sangmai, praying for. You have prayed for relief of writ of mandamus and certiorari. And also for quashing of the FIR.
Yes.
You have also prayed
Lord.
for,
Washington.
praying for quashing of the FIR and other reliefs in connection with Tejpur PS case number 726/2023. The petitioner is apprehending his arrest in connection with the said case, which has been registered under section 386 of the Indian Penal Code, read with section 10/13 of the Unlawful Activities within bracket Prevention Act 1967. Learned counsel for the petitioner. The learned counsel for the petitioner has submitted that on 4/9/2020, on 3/9, sorry. On which date FIR was launched? 26/8.
26/8/2023.
On 26/8/2023, one Shri Shankar Sensua had lodged an FIR before the in charge of Lalmati Police Outpost under Tejpur Police Station, inter area, alleging that on that day, the wife of the first informant received a demand letter from Assam Sanjukta Mukti Bahini within bracket alpha, demanding a cash amount of rupees 10 lakhs. And thereafter, on the same day, the informant also received phone calls from mobile number 9485268258 with regard to the said demand. Stop. Learned counsel for the petitioner has submitted that as submitted that as section 43D, capital D within bracket 4 of the Unlawful Activities within bracket Prevention Act 1967 provides for a bar of applicability of section 438 of the Constitution, 438 of the Code of Criminal Procedure in offenses involving under unlawful activities within bracket Prevention Act, 1967. The petitioner has filed the instant criminal petition, instant writ petition. Stop. It is also submitted that the petitioner has also cited a ruling of the Apex Court of India in Hema Mishra versus State of UP and others, reported in 2014, 4 SCC 453, wherein it was observed by the Apex Court that do you have that case? Hema Mishra. What was observed? That
Para 27, Madam. Honorable Court has said at the same time, as rightly observed in para 21 extracted above, the High Court cannot be completely denuded of its power under Article 226 of the Constitution to grant such relief in appropriate and deserving cases, albeit this power is to be exercised with extreme caution and sparingly.
para 20, para
27.
Court para
21 and
as
27.
observed as follows.
Lot.
Para 27
And 21, Lord.
and 21 only. Sir. Learned counsel for the petitioner has also submitted that the petitioner is a national level mixed martial arts player and has represented India, has represented at national level in mixed martial art games on several occasions and has also won gold medals. It is also submitted that the allegations level that the petitioner has not been named in the FIR. However, and he named in the FIR and he is in no way involved in commission of the offense alleged in the FIR. However, as police has visited his residence
On suspect.
on several occasions. On how many occasions?
2-3 times.
On several occasions, he is apprehending his arrest in this case. Stop. On the other hand, learned government advocate, Mr. D. Nath, has submitted that as the allegations leveled in the FIR and the offense involved in this case is of serious nature, and as the FIR is also a very old one, he may be given at least 7 days time to seek necessary instructions in this regard. Stop. This court is of also considered opinion that considering the nature of offense involved in this case, the case diary would be required.
Logic.
the perusal of case diary of H4 PS case number 726/2023 would be required. Now, why government advocate is defending? Why not public prosecutor?
But since this is
Because
a-
it is a writ petition.
it is a repetition criminal.
But it is in the nature of anticipatory bail application only.
But it is under 226 law.
Okay. Will you be able to produce the case diary?
Yes, sir.
Let the case diary be called for fixing. Third April, also issue notice to the respondents.
I'm appearing, madam.
Since learned government advocate has appeared for all the respondents, no formal notice need to be issued. Let this case be listed again on.
Till that does it, no process of them.
When will you produce?
I need,
Shortest.
I need 7 days time, bro. I need 7 days time. No, no, no.
Adin.
On 28th, no?
On 27,
28.
on 28,
Yes.
28,
28/3.
2023. The prayer for interim protection to the petitioner shall be considered
On that day.
on that day.
This month, last week, let's say, he has a game at Maharashtra.
This month,
This month.
that you have mentioned,
Then not mention overcome he informed him.
that you have to mention if you want to take benefit.
After filing this case, he informed me. Therefore, if possible, Lordship, if possible, he is anytime ready to appear before IO, Lordship, if possible.
Where the games are there, where you have to appear.
Last month of March, he said,
Where the,
that.
those details you have to if you want to take benefit of that, you may file an additional affidavit immediately, bringing that on record. And then we will consider granting you interim protection on that ground.
Otherwise, SI also invest his, I think, Lordship. Lalmati police. station.
Otherwise, on 28,
On
28.
no,
If you have any urgency, in between, you can approach this. In next. 12. 12 is similar.
Similar,
Same
that's it.
person, case is different.
PS case number is different. Otherwise, all are similar.
The allegation,
Delegation also same. Here, Lordship. FIR lost. Bebejia outpost, police outpost under
I do believe, no?
Tezpur police station.
This is by different person.
Different person.
Similar allegation.
go to the gist of acquisition of in that mention that everything else will remain same. Yes, case will be different. And the gist of it, last case of gist of acquisition to mathematician. Last case. Regarding the plan.
PS case number is number 752 PS.
The case number will be different. Yeah. On, yes, on 38/2023, one Shri Ganesh Sahu lodged an FIR before the officer in charge of Bebejia Police Station, Bebejia Outpost under Sonitpur Police Station, inter alia, alleging that on 26/8/2023 at about 9:50 PM, two unknown persons came to the gate of the house of the first informant and handed over a letter to the son of the first informant, Resham Kashyap, wherein and on perusal of this and from the said letter, the first informant came to know that it was given by Assam Sanjukta Mukti Bahini within bracket Alpha, demanding a cash amount of rupees 10 lakhs. The said letter was signed by one Rubel Assam. Stop. Thereafter, it is also mentioned in the FIR that on 27/8/2023 and 28/8/2023, the first informant received phone calls from phone number 948-5268-258, whereby the demand of money was again made to the first informant. Also, everything will remain same except the case number. Same order, same day. Is this one?
Wait, please, Your Lordship. There is a 438 application.
Yes.
438 application, my lord. Your lordship will find the FIR at page 14, my lord. Page 14, my lord. My lord, second paragraph, my lord, one Naka checking, my lord. One track has been apprehended, my lord, where 29 numbers of cattle have been found, my lord. Second paragraph, my lord.
Okay.
And now the petitioner before your lordship is the, my lord, owner of this cattle, my lord. I have purchased the same, my lord. And your lordship will find from page 16 onwards, my lord, all the challans, my lord, I have annexed, my lord. Page 16 onwards, my lord. Please pull over. বেচাটার নাম মানে সোয়েনসো, কিনুতার নাম মানে মুজিবুর রহমান. I will appear before the IO, my lord. I'll produce all this, my lord, in original, my lord.
But my lord, at that time, my lord, they could not produce. That is your time.
Third, I forgot your name.
MP Goswami.
Third, Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 438 of the code, we can dispose it of instead of calling for case diary.
Yes, sir. Generally, my lord.
Generally, my lord, CD
No,
will
let
call for
them-
and the IO verifies those receipts, my lord, whether.
No, we will dispose it of, let them appear. If they default, they'll be arrested if there is any violation.
Yes. My only my lord, prayer, my lord, that I have called for this prayer for the
Okay.
CD, my lord.
Okay. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mujibur Rahman, who is apprehending his arrest in connection with Vasishta PS case number 131/2024 under section 120B/379/429 of the Indian Penal Code, read with section 13 within bracket 1/16 of Assam Cattle Preservation Act 2021 and section 11 within bracket 1 within bracket small d of the Prevention of Cruelty to Animals Act 1960. The gist of accusation in this case is that on 2/3/2024, one Matlab Ali, ASI of police attached to Jorabad police outpost, lodged an FIR before the officer in charge of Vashishta police station, inter alia, alleging that during mobile patrolling conducted by the first informant and the other police staff of Jorabad police outpost at Jorabad area, a vehicle bearing registration number UP 21CN 2107 was intercepted, and it was found that it was carrying 29 numbers of cattle illegally without any valid documents. Learned counsel for the petitioner has submitted that the petitioner is the owner of the said seized cattle. Where you have purchased?
From my lord, it's my lord, Kolyapani Saturday Weekly Government Animal Market, my lord, under East Jorhat Anchalik Panchayat, page 15, my lord.
And he has purchased the said cattle from Kolyapani Saturday Weekly Government Animal Market under East Jorhat Panchayat. And in support of his submissions, he has produced the receipt of the purchase of the cattle issued by, who has issued it?
My lord, it has been issued by the, my lord,
No, Pune, who had issued?
my lord, the official, my lord.
Receipt of expense issued by particular. Stop. Learned counsel for the petitioner has submitted that the petitioner is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing. Yeah. After the second. Second April. 2nd April. For case diary. However, in the meanwhile, as the petitioner has produced the money receipts, has produced the receipt of purchase of the said animals today, it appears that he is the owner of the seized cattle, and therefore he is directed to appear before the investigating officer of Vashishta PS case number 131/2024 and cooperate in the investigation within 10 days from the date of this order.
Well,
if he does so within the stipulated period of time, in the event of his arrest in connection with Vashishta PS case number 131/2024, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1. That this case will be stayed again on 1st of April. 2nd of April.
I'm obliged, my lord, deeply obliged.
Item 41.
438 application, probably also here also record will be necessary.
NDPS.
NDPS.
Also from the vehicle from which contraband were recovered, only one permit in the name of the petitioner was.
It is pending investigation.
No, charge sheet is submitted.
Charge sheet is
Charge
submitted.
sheet submitted. NBWA issue. And my case is that Lordship, only that vehicle was already sold to him. Lordship may kindly see. My
When
parents
is
are-
the next date fixed?
next date is tomorrow. So
You will not appear tomorrow.
tomorrow, Lordship, NBWA is there, will be taken.
No, you are not arrested till now. You can appear before the court and
But NBWA, and if I go there, I will be put behind bars because of that NBWA.
no, before execution of NBWA. The manner in which you have approached this court,
Right.
you can directly approach the trial court also.
In that case, Lordship, if my bail application is rejected, I will be put behind Lordship. So here I'm. Lordship may call for the record and on merit also, Lordship, I have case because Lordship, only that national permit was in my name. Vehicle I was already, the vehicle already I have sold. Your Lordship is aware that when insurance is there, insurance in insurance paper, my name will be there. But when I transfer the vehicle owner's name will be subsequently added in insurance paper when he renews it. That prior to that, that documents will remain same. And accordingly, my name is, it was there in the national permit. Apart from that, my involvement is not there. That it shall be the FIR, it shall be, your Lordship will find that part. Page 16, serial number 3.
In anticipatory bail also, embargo of 37 will be applicable.
Yes,
Yeah, if I can satisfy on merit, then I have a case, Lordship. That reasonable ground that I will satisfy on the day when records are here.
What will happen if during the pendency of this bail application you are arrested? It will become
That's it,
infractus.
it will become
Infractus.
infractus.
But there will be no bar.
There
There will be no bar.
Okay. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This anticipatory bail application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, same petitioner,
Petitioner is same.
Qazi
And he
Ghulam
came-
Mustafa, who is
The latest
apprehending
name.
his arrest in connection with
Sorry, number of.
Bajari Chera PS case number 114/2022. Under corresponding to special NPS case number 96/2022. Under section 20B2C/25/29 of the NDPS Act, 1985, pending in the Court of Learned Special Judge Karimganj. Perusal of the scanned copy of the case diary of Bajari Chera PS case number 114/2022, as well as scanned copy of the NDPS case number 96/2022 would be necessary for consideration of the instant bail application. Hence call for the same. Registry to issue requisition for the aforesaid scan copies. Let this case be listed again on 9 Feb
2012.
22 April.
Yes. Lovely.
Item 42.
And we will look it. Madam, this is a 438 application. Yes. The petitioner is a lady, and the allegation is under section 420, 384 and section 12 of the Money Laundering Act. The petitioner. as per Money F- Lenders Act.
Yes, as per FIR, my lord, page 12, petitioner now is not a named accused in the FIR. And police raided the house of the petitioner 2-3 days, and thereafter the petitioner and her husband had an anticipated bail application before the learned this additional session judge Gusaigao, and the learned session judge granted in bail application, anticipated bail application in favor of her husband. The next step,
2, my lord, page 15. But not granted the application, granted the interim bail in favor of the present petitioner. That is why the petitioner is present before this.
In view of rejection of your anticipatory.
Yes.
So this is your second anticipatory bail application.
My lord, this first anticipatory bail filed it before the court.
But anyhow, this is the second
It is the
anticipatory.
And now it is second, my lord. That is second, my lord.
So you have to justify also why
My,
second.
my, justify my lord, the petitioner is not a named accused in the present FIR. Though there are 3 names in the accused list, page 12, my lord. But the petitioner name is not there. Furthermore, during the consideration of the bail application of the husband, my lord, nothing incriminating was found against the present petitioner, my lord. So that is, even though the learned court below was not inclined to pass the order on the ground that since it is initial stage. So after some time, the same may be considered. That is the observation, my lord. Whereas nothing was produced before the court below, nor any incriminating materials after that found by the police, my lord. And she is not a money lender.
Whether the court of additional session judge has perused the case diary.
Yes, my lord.
After perusal of the case diary, this order has been.
Yes, after perusal. Paragraph
So
2.
we'll call for the case diary. And you have to justify all the requirements of moving a second anticipatory bail application to.
My lord.
Not now, on the date of this, because today you will not get any relief.
My lord, she is a lady and she is not at all involved with the offense, my lord. Section 420 does not arise unless she is a money lender. How section 420 will come? Apart from the section 384, section 384 is extortion. How she will extort? She is a lady, and her husband is a government servant, my lord.
But as your one anticipatory bail application was rejected by a court.
I respectfully agree, but respectfully, my lord, last paragraph, in view of the above, I decline to enlarge the accused petitioner Chandravati Burman to go on fierce bail, and her fierce bail application is rejected. The ground was not mentioned clearly. However, there is no enough materials in the CD regarding the involvement of accused petitioner Sochimon husband. And I am of the view that no custodial interrogation may be required for the purpose of investigation. So it is ordered that.
We'll fix it shortly. Heard, Mr.
But in the meantime, my lord, interim may be considered. She is a lady, she cannot go, my lord, at 45 years old. Because 480, 380, and section 12 is not at all applicable. Nothing was found. And the informant lost the FIR on the basis of information and on the pre-accused, my lord.
Yes, Mr. Goswami. Second.
Lordship, my lord,
anticipatory bail application.
yes, my lord, lordship will find from the paragraph, my lord, that after perusal of the CD, my lord, though it is as per my learned friend, my lord, the reasons are not recorded, but after perusal of the CD, one is allowed, other is rejected.
So
The
there are
meaning thereby, my lord, there will be materials in the CD.
Heard,
my lord.
Mr.
But nothing was incriminating transparent of the record. As
We
per the record,
we
my
will
lord.
peruse the case there.
Yes.
Heard, Mr. A. Ahmed.
I Talukdar, my lord.
Heard, I. A. Talukdar, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Srimati Chandravati Burman, who is apprehending her arrest in connection with Gosaigaon Place case number 29/2024. (384/34) of the Indian Penal Code, read with section 12 of the Assam Money Lenders Act 1934, It appears from record that before approaching this court, the petitioner moved an application under section 438 of the Code of Criminal Procedure before the learned additional session judge Gosaigaon, which was rejected by order dated 11/3/2024 after perusal of the case diary. Hence, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the same.
My lord, in the interim, she is a lady and her husband is a government servant, my lord. She will not abscond or shall not do anything.
Next
At the
paper,
in
I am
the
praying.
event, my lord, she may be protected, my lord.
28, my lord, after next week.
She may be protected, my lord. But nothing was found incriminating against her, my lord. That may be
No,
considered.
you have not produced any new thing from the date of rejection after perusal of the order. Earlier anticipatory bail application was rejected. Something you are repeating the same submission which you made before the Court of Additional Session Judge. Therefore, without perusing the case diary, this court is not in a position to come to a decision.
My lord, unless I have incriminated, I am involved, how can I produce before this honorable court that I am involved or I'm not involved, my lord? I am a member of SHD.
Therefore,
I am not at all involved, my lord. And as per the FIR, my lord, can you have a look at FIR 12, my lord?
How short you can notice?
My lord, at least being a lady, at
No,
least she will be
25.
protected, my lord.
No, merely because you are lady.
Yes,
Though
23.
you will get preference.
Yes, 20.
But once your prayer is rejected, then at least perusal of the case diary is necessary. 27/3.
27.
27/3.
Item 54 from supplementary.
May it please the lordship. Well, at 430 bail application, my lord, last occasion, my lord, the report was called for, my lord, as to whether any affair has been lost at Nalbari PS or not, my lord. Here, my
But
lord,
instruction we have not received now, madam, regarding from the Nalbari PS, madam. If any case is registered, madam, that instruction we have to bring, madam.
my lord, last two occasion, my lord.
Today also we have called for, madam.
Now,
but it is-
suppose we don't get the
My
instruction,
lord, my lord.
what order I will pass? In which case you will get protection? There has to be a case.
Yes, that is why, madam.
Definitely, my lord, they have must to obtain instruction, my lord.
Heard Mr.
As of, my lord.
S. Hawk, learned counsel for the petitioner. Also heard Mr. M.P. Goswami,
Yeah.
learned additional public prosecutor, who prays for some more time for some more time for producing the. No, who submits that though the by order dated 14/3/2024. No. The additional public prosecutor was directed to collect a report with regard as to whether any case is registered in connection with the case is registered against the present petitioners in Nalbari police station. However, same could not be collected, hence he prays for some more time. The officer in charge of Nalbari police station is hereby directed to furnish a report to this court through learned additional public prosecutor as to whether any case against the petitioner, namely Parveen Sultana and Jiaur Pasa, has been registered in the Nalbari police station or not. In case any case has been registered, the details of same shall be furnished along with the said report on the next day. Let this case be listed again on
Sir, Friday, my lord, the next, if I'm taking a short, whether it will be possible or not.
on 22/3/2024.
My lord, till date, no coercive action.
No, my lord,
In
that-
which case? I am ready to give you, but in which case you tell me in which case you, because blanket
Yes, yes, we can.
protection will not be granted. But if you are able to tell me the case, I am ready to protect him.
My lord,
Lord.
During the item number.
Obliged.
May it please your lordship. Lordship, 439 bail application, lordship, on the last occasion, lordship, there was deliberation regarding the overcoming of the rider of section 37 of NDPS Act, lordship. And lordship, after that, lordship, there was another deliberation regarding the length of detention. At 1 year, 6 months, lordship. Now, sir, lordship, my length of detention is now today 1 year, 7 months, 17 commercial quantity, lordship. And one witness has also been examined, lordship, out of.
আমার instruction নাই, আমার last 6-2 লৈকে আছে evidence ৰ কাৰণে fix আছে।
Lordship, I have this certified copy of the evidence also. One new thing I would like to submit before this lordship.
No, the case is charge sheeted under section
20C, BC.
20B2C. NDPS.
ganja.
40.30 kg ganja. 40 kg.
Lordship, may kindly see the cross-examination part, lordship.
Driver.
Independent witness.
This is a driver by profession.
How many witnesses have been recorded?
So far, one witness has been examined, lordship.
Only one.
Only one. There are 5 to 7 witnesses. A list of witnesses 7, lordship. 7 witnesses are there, list of witness. One witness have been examined. Lordship, I just want to highlight, lordship. In the FIR, this person, Pinku Lalung, is portrayed as the independent witness. I will read the relevant lines, lordship, in the FIR. The FIR is at page 16. But before that, lordship, can kindly see the cross-examination part. He's saying that he has no knowledge and he has simply put his signature on a blank paper given by the police. And now what the FIR is saying, I would just like to read the relevant portion.
When this case is fixed next?
Next. 26th, lordship.
March.
26th.
For evidence.
For evidence. I filed an additional affidavit also, lordship. The parents of he's a first time offender, lordship. No previous cases, lordship.
No, your case is on prolonged incarceration.
Lordship.
On the
Lordship. One year, 7 months, 17 days, lordship. I was arrested in the year 2022. Date of arrest is 1/8/2020.
No, on 26, there is a possibility of examination of witnesses.
Yes, lordship. For a moment, lordship, just I want to highlight this, that the witness that has been examined, which is one of the vital witness, he is saying that he was picked randomly. So for a moment, if we imagine, lordship, that if this person is really innocent, the amount of hardship he is undergoing, lordship, more than 1 year, 7 months, he is behind the bars, lordship.
No, but okay. We'll fix this case after 26. We'll see whether any further witness is examined or not. Then we'll consider your
lordship.
Because the report, this is produced by you. The report available on record only mentions about framing of charges.
Lordship. This is the original certified copy, Lordship.
No, record. So up to date,
No.
scan copy is required.
We'll hear this on next day, after the, one more chance is given to the trial court, so that some witness. So how many witnesses are there?
5 listed, my lord.
5 listed in.
So out of 5.
One has
one-
been examined.
One has been,
That
only
is-
4 are remaining.
These are
Four may be
One
exa-
is independent witness, the rest are government witness.
4 may be examined on the next day. If they are examined, then your case is over. Heard,
Dr. P.P. Methi.
Dr. P.P. Medhi. Learned counsel for the petitioner. Also at Mr. B.B. Gogoi, learned additional public prosecutor. It appears from record that as per the status report of the case, of the NDPS case number 235/2022, pending before the Court of London, additional session judge number 3 within bracket FTC, Kamrup Metro. No witnesses have yet been recorded. However, learned counsel for the petitioner has produced the certified copy of the deposition of PW1 and has submitted that on 6th February 2024. Only one witness has been examined by the trial court. It is also submitted by learned counsel for the petitioner that the petitioner has already been detained behind the bar for more than 1 year, 7
7
months.
months.
And more than 1 year, 7 months, stop. It is also submitted by the learned counsel for the petitioner that there are total 5 number of listed witness in the charge sheet. And and only 4 listed witness are remaining to be examined. And the next date is fixed on
26th, 3/2000.
26th,
26th, that was 26th.
26th, 2024. Considering the submissions made by learned counsel for the petitioner, this court is wait till the next date fixed before the trial court to see, with a hope that the remaining witness may be examined on the said date.
26th.
Stop.
Holiday.
Let-
Holiday 26th.
Let a status report be called for from the learned additional session judge number 3, Kamrup Metro, informing this court as to the number of witnesses examined on 26/3/2024. The said report shall be furnished to this court after the said date, that is 26/3/2023, and before the next date fixed. That is 5th of April. 2024. Let this case be listed for bail hearing on 5th of April 2024.
I'm obliged, Lordship.
Item 46.
May I please, your Lordship? Lordship 439 application, Lordship, and allegations are under section 20B2C and 29, Lordship. And petitioner is Lordship behind the custody since 2310, almost 5 months, Lordship, 148 days today, Lordship. And nothing has been recovered from his possession, Lordship. And petitioner is the owner of a vehicle, Lordship, Hyundai vehicle. And the police has seized 92.745 kg of suspected ganja, Lordship, from the vehicle, Lordship. But that vehicle was found in abandoned condition, Lordship. And the petitioner is the owner of the vehicle, Lordship. And Lordship, I have stated in paragraph number 7, Lordship, page number 4, that the petitioner is the registered owner of the seized vehicle Hyundai bearing registration number so and so, where the suspected psychotropic substances were found, Lordship. But the petitioner insisted that the said vehicle was running by one Hada Ali and Jitu Ali of his village, Lordship, for the past few months on verbal agreement, Lordship. And further, Lordship, the petitioner has no any suitable place for parking of his vehicle, Lordship. Hence, he handed over his vehicle on verbal agreement to that people, Lordship, Hada Ali and Jitu Ali. But Lordship, that accused were not arrested, Lordship, and I am behind the custody since 5 months, Lordship. Lordship, considering the detention period, Lordship.
Diary received without FSL report.
Investigation is going on.
Investigation is going on, my lord. Last note shows that, my lord, they communicate with forensic laboratory, but till that report not received, my lord.
Lordship, today is the 4th occasion, Lordship. How long I will wait, Lordship? Always they are asking time for FSL report, Lordship, but police has not sent the FSL report, Lordship. In other cases also, Lordship, I have waited for 8 occasions, Lordship.
Yes, diary also here, my lord.
Assuming that what has been found?
Yes, ganja.
Ganja.
Ganja, Lordship.
Assuming the contraband to be ganja, then see her case.
Yes.
Suppose it is not ganja, then it will favor you.
Yes.
Assuming that it is ganja, then whether you have a case or not. Let us see that.
Lordship, FSL report, police cannot collect, Lordship. In my other case also, police has Learned Friend have taken time for the 8 occasion, Lordship. They could not collect the FSL report, Lordship. So this is the general practice, Lordship.
No,
So how long
this
can we
diary
wait,
is not
Lordship?
up to date also, my lord. Diary is up to 12/12/23.
Lordship, kindly peruse page number 19, Lordship, where bail objections were given by the police, Lordship. And there, Lordship, bail objections, last para, Lordship. Under the above facts and circumstances, it is therefore prayed that your honor would be pleased to admit that the accused person may not kindly be released on bail at this primitive stage of investigation. If he released on bail, he may hamper and tamper in the process of investigation, Lordship. So, Lordship, in this matter, Lordship, the process of hampering the process of investigation does not arise, Lordship. Since I am in the custody since 5 months, Lordship.
In this case, whether there are materials to reasonably believe that you are involved in the offense or not, because section 37 will be applicable. So unless this court comes to a conclusion that you are innocent, you may not get bail. So you have to satisfy this court that you are innocent, though the vehicle belongs to you.
Yes, Lordship. Vehicle is.
So how will you satisfy?
And
When
in
the
the
vehicle is
FIR,
your,
Lordship, it is found in abandoned condition, Lordship.
and
The
you have
vehicle was-
rented it out to some other person,
Yes, Lordship.
but oral then.
Oral agreement, they were running my vehicle, Lordship. I am innocent, Lordship. That is why considering the detention period, Lordship. At any condition, Lordship, I will
No, detention
cooperate
period
with the
is,
investigation, Lordship.
detention period is less as per the standard set by Supreme Court.
Yes, Lordship. 6 months is the detention period, Lordship. And in
Apex Court is granting bail on ground of prolonged incarceration only to those cases where at least 1 year, 6 months has lapsed.
Mm,
So you have completed only
5 months,
five
Lordship.
months.
But
So unless so that prolonged incarceration ground may not help you. If otherwise, we'll go through the case diary.
Let me, kindly
This
peruse the
diary is
case
not up,
diary.
the diary
Up
up
to
to
date
12,
till
12 only, 12, 12 only.
12.
23, yes. So up to that diary is required.
And
Madam,
I was
Along
arrested
with
on
FSL
Lordship
report.
2310, Lordship.
When you will produce up to date. case diary.
This is from Rongia, my lord. First week, any date, my lord, first week,
Case diary has to be up.
yes.
First of then, Lordship, it will be 160 days, Lordship, the detention period. There are not
80 days,
any,
180 days, your
oh, sorry, 180 days will be.
Then you will automatically get paid.
Today is 148 days. They have not
detention
furnished any
2310.
charge sheet, Lordship.
No, 2310 to my detention.
2310, as a 148
11,
days.
12, 1, 2, 3, 4.
148
23, 4 tomorrow complete.
Third, Ms. G. Dhaka,
Roughly question.
learned counsel for the petitioner. Also heard Mr. B.B. Goswami, learned
Gogoi.
additional public, B.B. Gogoi, learned additional public prosecutor. It appears from the order dated 5/3/2024 that the prosecution side was directed to submit an updated case diary along with FSL report. However, today also, the updated case diary has not been furnished. And learned additional public prosecutor has prayed for some more time. Considering the fact that the offense in this case is an offense involving commercial quantity of contraband, one more chance is given to the prosecution side to produce an updated case diary. Without fail, on the next date, when will you produce?
9/4.
It kindly last week of March, Lordship.
নাহিব
it be on
আমি
9th
ৰিটাৰ্ণ
of
কৰিব
April.
লাগিব ডাইৰেক্ট তাৰপিছত আপডেট কৰিব লাগিব it will take time.
Let this case be listed again on 9th of March,
9th of April.
9th of April
April.
for updated case date.
Okay.
Ma'am, please, Lord. See, this is 439 application, Lordship, and here in this case, Lordship shall cases registered under NDPS Act, Lordship, but the fact is that, Lordship, some branches of cannabis, Lordship. And we'll find, Lordship, and the page number 11, kindly come to page number 11. The middle portion, Lordship, A and B, Lordship. A and B, page number 11, Lordship. And the middle portion, A, capital A, there are.
There is there.
Diary without FSL, my lord, same.
Hello, kindly just for a moment, Lordship. A Lordship, capital A in the middle portion, Lordship. 3 numbers of red color plastic polythene containing suspected to be cannabis, ganja, marked as A, B, and C, net weight A, B, C, 6.4040 kg, and B so and C so respectively, with plastic polythene, and NB, Lordship, the plastic polythene marked B and C is containing branches of cannabis, ganja, plant, kept in the plastic polythene, and Lordship, and if we left lost the A Lordship, then it will be amount of about 20, Lordship. But all these are not the all branches of cannabis lordship. And then these are the tree of lordship, actually lordship. And lordship nowadays lordship and nowadays not lordship and this cannabis lordship and the village area naturally grown lordship. And someone used for their purpose and someone are
What
damaged.
is your submission?
And lordship and these are the branches lordship,
So,
cannabis, not leaves lordship. Leaves
so
is
this
used
is
for
not ganja.
not ganja lordship, branches lordship.
For that, we have to consider the
And otherwise I'm
FSL report.
lordship and 20 kg, not
No, no, 26.54 kg.
no lordship. And
Caesar,
B and C, B and C.
yes.
A is not here lordship.
And
And
A is
A is lordship plastic polythene lordship. And it will be reduced from the total weight lordship. And A is lordship 6.40 kg.
what is the total weight of the?
And if we will not calculate the A lordship, then it will become 20 point something lordship.
Point something, then it will go beyond.
Exact lordship, but it is not the ganja lordship. It is branches of cannabis, branch lordship of a tree lordship. Very clearly mentioned branches of cannabis, and only leaves are used for that.
15.
And these are the green tree lordship, and they have collected and already waited lordship. And otherwise
Yes.
lordship,
Yes, and that is Caesar shows my
No,
26.54
no,
kg.
he's saying his submission is that what has been seized is not ganja.
Yes. Then my lord, only forensic will my lord confirm. We cannot say,
Then you will detain the person.
no, no, my lord, we are not sure that these are not ganja.
Then you cannot detain.
No,
If you are not sure.
no, that is the reason, my lord, why we sent it sample to forensic laboratory to confirm the, my lord, contravention.
Have to make a prelim, if it is flowering.
Now it is suspected to be ganja, my lord. We yet to come, my lord, the report. We send it to forensic laboratory only to confirm it, my lord, whether it is ganja or my lord,
lordship,
whatever.
FIR and forwarding report, there is nothing mentioned, and this sample is sent for the FSL lordship.
Yes,
There is nothing mentioned lordship.
that is there in the diary, that is there.
And lordship and otherwise cannabis, branches of cannabis lordship. So how can it will be ganja lordship?
Branches cannabis may not be ganja in.
And I'm
Yeah,
saying this is-
that's why we send it to forensic laboratory to confirm it, my lord. When we choose, my lord, heroin, suspected to be heroin, my lord, always suspected to be heroin.
That's
We
what,
may confirm it from the report, my lord, FSL report.
No, but prima facie, you have to come to a conclusion that this is prima facie. You have to use
Yes,
the kit to be, to the IO must have the drug detecting kit, preliminary kit from,
yes.
or the,
Here it is, Caesar list shows, my lord, that, yes,
lordship, seizure list, FIR forwarding report is
we'll
very
take it
clearly
up
mentioned.
tomorrow.
Lordship,
Tomorrow we'll take it up.
lordship.
You only look into, is there any material in the case diary which says that it is flowering top of the ganja cannabis plant?
that is not
If
mentioned.
it is not flowering top, so
Yes.
from where we can assume that it is ganja.
Yes,
If it is only leaves and branches without flowering tops, it may not be ganja.
Lordship.
here it
So
is not.
prima facie something has to
Yes,
be there.
yes, lordship, here it is not mentioned in the Caesar list. Caesar list is this
You go
mentioned
through
that
the
ganja.
case and tomorrow we'll ask. This was hearing matter.
Lordship, hearing matter. Lordship.
Heard Mr. F.A. F.A. Hawk, London Council for the Petitioner. Also heard Mr. B.B. Gogoi, London Additional Public Prosecutor. The hearing remained inconclusive due to positive time. Let this matter be listed on 19 March 2024 as part of the.
Lordship, I'm sorry, Lordship, and the fasting is going on at 2 Lordship tomorrow, any possible. Lordship, obliged.
My lord, legal lordship. My lord, I beg to mention the lordship, item number 43, lordship. So lordship, here in this case, lordship, the petitioner has been a long incarceration for
more than 800 and lost it 10 days, you lost it. 2 years already been elapsed, lost it, and the progress is only 2 prosecution witnesses have been examined in lost it, PW1 and 2. And there's a total contradiction between PW1 and PW2. Which we lost after recited for all the PW1 and
What
2.
is your prayer?
My prayer is lost may be fixed on day after tomorrow. Because I have been in long incarceration for more than 2 years in lost. Day after tomorrow, lost.
Okay, whether court working hour has been extended?
Lordship,
For 30 years.
Till when court working hours? It is till to point out.
August. It is extended to 415 you lost it. Earlier it was 4.
It is Sudeep. Bring it to notice of the registry, so that cause list may be.
May I please, your lordship, item number 50.
Lordship, what to the end? Lordship, my item number, date is not fixed in lordship. Otherwise, I would not have insisted in lordship because I'm more than 2 years in lordship. Day after tomorrow in lordship, 43 items.
Okay, day after.
May I please, your lordship, item number 57, lordship. This is the 4th time, lordship. The case was never heard, did not heard, lordship. It listed but not heard, lordship. It was filed on 12th December 23, lordship. So kindly day after tomorrow, your lordship. If time permits.
If all cases are fixed day after tomorrow, then same.
But unfortunately, the matter has been listed before.
Item number?
Item number 57 from supplementary, lordship. It never reached, lordship.
Okay. Day after.
My lord,
Other.
My lord, item number 55, my lord.
Let me.
2 days, 59 days, my lord. My case, my lord.
What is your submission?
My lord, 59 days today, my mandatory period will be over tomorrow, my lord.
Tomorrow you'll get bail.
My lord, it's
Without
pending,
any order.
it's pending here, my lord, that's why, my lord. So, see, case diary, my lord. Can it be on tomorrow, my lord? Tomorrow.
Item 50 minutes on Thursday. Minutes. Delay condemnation prayer is there. It's a appeal minutes.
Item 50 Thursday.
My lord, item 44, could it be on Friday, my lord? The CD is already there. It may be retained.
No,
My lord, item 50.
You
My lord,
make.
51, my lord.
My lord,
Fix a date, my lord.
44, my lord,
Let
Friday.
me, let the
Item
court master
56,
give
my
it.
lord.
Well,
Very
item
well.
number
Obliged.
32, my
Item
lord,
is
for
kindly
today's
fix
list,
it
my lord.
22.
My lord, yes, I just delayed petition, my lord, criminal revision, but I just stay concept is because the petitioner is a CRPF personnel working in Maharashtra and a warrant is there. So may I pay it for come on 20th, my lord, day after tomorrow, my lord.
No, we have to see our cause list.
Because my lord, he is working in the CRPF. my
You
lord,
make
posted
prayer.
in Maharashtra.
He will accommodate. Accommodate.
Well,
Accommodate subject to our cause list, because if cause list on some day, if cause list becomes again same, then it will be difficult.
In item number 41, only I am asking for a date, only date, because.
It will be given by.
Only date, maybe,
Item number 13, today is 86 days, 90 days mandatory period. May come up on Friday.
Court master will give date. Wherever special request is made, give a date. Otherwise, it will be left over. Your request 9, those will be shown as left over. Wherever there is interim order shall.